Gentlemen, to the regular meeting for January 25th, 2016 of the San Francisco Ethics Commission. I'll call the roll. Commissioner Andrews. Here. Commissioner Han. Commissioner Herr.
Here.
Commissioner Keene.
Here.
I'd let the record reflect that all commissioners are here and accounted for. Item number 2, public comment on matters appearing or not appearing on the agenda, and I would urge, if you have comments that relate to matters on the agenda, to hold them until we get to them, because I think this may be a long meeting tonight, and I'd like to minimize the repeat statements. But anyway, let's go.
Ms. Pell? Oops. Wait a minute. Don't start the clock until I get that.
We've missed you for a few months.
And I've missed you, Commissioner.
Okay.
I'm Patrick Minette-Shaw. I am not prepared to thank Commissioner Ben-Hur overall for his years of service on the Ethics Commission, as his term is set to expire in early February. Many of Hur's rulings have been problematic, but I would be remiss by not thanking him for his seminal vote in La Affaire Mercurini, when he cast the Ethics Commission's sole vote that Mercurini's behavior had not risen to the definition of official misconduct. As I wrote at the time, a then anonymous analysis, which eventually turned out to have been authored by San Francisco private practice attorney Stephen Brill, that had been distributed to the full Board of Supes, and I believe to this body, before the two respective hearings, clearly demonstrated the mayor's trumped-up charges against Mercurini didn't meet the definition of official misconduct. Thankfully, along with Commissioner Herr, Supervisors David Campos and Jane Kim reached the same correct conclusion. Now with Herr's term expiring next month, perhaps the Ethics Commission can finally get around to investigating the probably illegal campaign contributions exposed in the Raymond Shrimp Boy Chow trial involving Nancy Mulhauser and Zula Jones, now that the district attorney has filed bribery and money laundering charges against the pair, along with former school board president Keith Jackson. The new charges against Jackson are apparently felonies, but it's not yet clear if Mulhauser and Jones are facing felony charges. With Commissioner Herr, a partner at Keeker and Van Ness, the law firm that is reportedly going to represent Zula Jones on a pro bono basis, soon to see his term expire, this commission must make it a priority to investigate all campaign contributions and money laundering charges aired against Jones and Mulhauser during the prosecution of Shrimp Boy. The Ethics Commission investigation is long overdue, and everyone knows, in the court of public opinion, Ed Lee was in the room with Mulhauser and Jones and the FBI agent, and he knew that meeting was about paying down his campaign debt.
Thank you. Your time.
You have to investigate this.
Good evening, David Pilpel, speaking as an individual. I too wanted to recognize the soon-to-end term of Commissioner Herr, and I actually was going to mention under item 8 that perhaps at a future meeting you'll have an appropriate recognition for Commissioner Herr and his good work over many years. Thank you.
I should tell you that the assessor has asked Commissioner Herr to remain beyond the February 1st date to our next meeting while she has an opportunity to vet a replacement. So all of the compliments that are very deserved for Commissioner Herr. We can save until February 22nd when his term may officially end.
One for you. One for you, and one for each of you. Members of the Ethics Commission, Ray Hartz, Director, San Francisco Urban Government, and you haven't seen me in a while, and I guess that's probably something you're not too unhappy about. I would like to refer this commission to a decision of the United States Courts of Appeal for the Ninth Circuit, which is, of course, this circuit. The case is Robert Norse versus the City of Santa Cruz in particular. I would like to suggest reading the concurring opinion of Chief Justice Kozinski, and each of you has received a copy of that. His opinion reads in part, listeners' reactions to speech is not a content for neutral basis, a content-neutral basis for regulation. Speech cannot be punished or banned simply because it might offend a hostile member of the Santa Cruz City Council. The council member should have known that the government may never suppress viewpoints it doesn't like. The defendants point to Norse's reaction to Councilman Fitzmaurice as the disruption that warranted carting him off to the jail. Norse's calm assertion of his constitutional rights was not the least bit disruptive. The First Amendment would be meaningless if Councilman Fitzmaurice's petty pique justified Norris' arrest and removal. And on the copies I gave you, if you look at the back, the Chief Judge also said that they did not have qualified immunity for their actions because they had they knew that they were not allowed to stop the comments. Now, the reason I mention this is I've talked about this before. Can I get the overhead, please? Can you stop my time while the overhead is? Oh. Well, my time's running away and they're not doing it. Okay. Okay, list won't fit on the screen, but I have 24 orders of determination. This is 24 times I have taken city agencies and officials to the Sunshine Task Force, and they were actually found in violation. And you know how much this Board of Supervisors has manipulated the task force to make their job difficult, and yet I still managed to go and win 24 times, which is a 70% success rate. And the reason I'm saying this is because it seems to be some sort of a belief that if you chair a committee or a task force or something in this city, that if you don't like what someone says, you can shut them up. You can interfere with them. You can say they're doing this or doing that, and you have to draw them into the task force. The task force comes out and says, yes, they violated your rights under the law. They pass it to you, and you don't hear it. Bottom line is, the last time I had one put over here, I was out of the state, and it was very convenient that it was announced the day that I left the state, and the hearing was held the day before I got back. And I've mentioned this to you, and not one of you seems to have a conscience. The also reason I mean it is because of this. I went to the city council one day, and because as I started to walk up to the podium as the next speaker, I said a loud word, and that's what I got. Since when does breaking a rule of a committee justify suborning someone's First Amendment rights? Unusual punishment.
Thank you. Any other? All right. Turning to item number 3 on the agenda, discussion and possible action on a request for waivers from local post-employment restrictions submitted by Evan Gross, a former deputy city attorney. Is Mr. Gross here? Do you want to come up and make a presentation?
Commissioner Rennie and members of the Commission and the public, if I could just make a brief comment about the process that we're here for members of the public who may not be that familiar with this process. Under the Commission's ordinances that it administers and enforces is a process for individuals to seek a waiver from existing post-employment lobbying restrictions that may apply to their circumstances. And when the Commission receives a request for a waiver from an individual, there is a requirement that the Commission consider and determine whether the waiver should apply. So we received at the staff a request from Mr. Gross earlier this month. The program requirements, the regulations require that we bring it to you at the next Commission meeting, which we've done. We have a recommendation in the materials tonight under agenda item number 3 that in this instance at the staff level we recommend that the waivers not be approved. However, the Commission has of course the opportunity this evening to hear from the individual and any others who might have a viewpoint that they would like to share with you. The Commission has certain factors to look to determine whether or not the waiver should be granted, and then is required to make some findings in order to waive the imposition of the post-employment restrictions. We can get to that perhaps after the discussion from Mr. Gross and others.
All right, thank you, Ms. Pelham. I do want to compliment the Executive Director and the staff for the thoroughness of the presentation that you did make in the package and laying out these various statutory provisions and the areas in which we must make findings. But unless any commissioner feels otherwise, I'm inclined to let Mr. Gross make his statement or presentation, and then we'll take discussion at the Commission level and at the public level. Go ahead.
Good evening, Commissioners. Thank you for your time and your willingness to hear from me tonight. And I want to thank everyone who's taken the time to speak or write emails on my behalf. There's quite a number of people who are here to speak on my behalf. I hope you'll give them the time to say their piece. And you've received a number of emails, and there's a few more in my packet that I presented. And I'd especially like to thank the Mayor's Office of Housing and Community Development and the City Attorney's Office, the two city departments that are most affected by my request. I just want to quickly mention a few names of organizations that support my request and make sure that you've seen those emails, all from the affordable housing community here in San Francisco. The Shanti Project, Episcopal Community Services, Treasure Island Homeless Development Initiative, Mercy Housing California, St. Anthony Foundation, Bridge Housing, Tenderloin Neighborhood Development Corporation, Chinatown Community Development Center, and Community Housing Partnership. They all are in support of my waiver requests. Hopefully the information that I'll provide to you now and that you'll hear from some of them or have been provided to you will help you see just how important this decision is to the San Francisco affordable housing community. I want to just make a few points to give you a little more context and so that you can clear up some misconceptions that were included in the Executive Director's report, so that I can show you that because of the unique relationship and the mutual interest shared by the city and by my nonprofit affordable housing provider clients, granting this waiver would not create potential for undue influence or unfair advantage, and that denying this waiver would not protect the public interest but would actually hurt it. And I just want to apologize in advance for the length of this. I'll get through it as quickly as I can, but this is incredibly important to me. And this is my one chance to present to you all of the reasons why you should grant this waiver. So
How lengthy are we talking about?
I will get through it as quick as I can. 10 minutes or so. I understand that you've got a long evening, and but this is my life, this is my livelihood, and it's affordable housing in San Francisco, and I'd like the opportunity to at least say my piece, because I don't feel that the Executive Director's report fairly represented what you're being presented with.
Mr. Chair, we have many very important items that people present, and we keep them to 4 minutes.
Right.
I don't see why we should make an exception in regard to this case.
I don't think there's a 4-minute limit for these particular waiver requests. I think those are the sunshine matters, but of course it's to...
I'll run through it as quickly as I can, I promise.
The concern I have is that you said that there are errors in the executive director's report. What are the errors? I've read
I apologize. I'm not errors, just misconceptions, and just I think there's some context that's missing from the executive director's report that I can provide for you so that you can better understand how the affordable housing community works here in San Francisco and how it works with respect to how the city works with them and how the interests are mutually aligned between the city and the affordable housing nonprofit providers that I would represent, and also to present to you at least a little bit more context of what I'm actually doing, what I have done for the city, and what I will do for the city. That's all I'd like to present to you. And if I can do that very quickly.
All right, do it as quickly as possible.
I appreciate your time. So first and foremost, I just want to say that I want to point out that the City Attorney's Office, the Mayor's Office of Housing and Community Development, and all of the significant nonprofit affordable housing developers in San Francisco unanimously and emphatically support my request. The only two city departments that I'd be working with and that are impacted by this, and everyone who works in the affordable housing development world, are telling you that the nonprofit developers and the city share mutual interests and are not adverse parties. And they're telling you that preventing me from working on the city's most significant affordable housing projects at a time when affordable housing is the #1 priority issue in the city would severely hurt the city and the public interest. They're also telling you that allowing me to communicate with the city and work on these projects would not create a potential for undue influence or unfair advantage, and that allowing me to continue with this work would be beneficial to the city and the public interest. I believe that that should matter more than a rigid reading of the post-employment ethics rules. You're not going to hear a single voice of dissent out here, and with the exception of the executive director's report, which, with all due respect, is not as familiar with the affordable housing world or the nature of our work, and who gave no weight to the fact that the City Attorney's Office and the Mayor's Office of Housing, who are, again, the two city departments that I'd be communicating with, both emphatically support my request. I think is especially significant in this case where the City Attorney's Office, where I'm held as an attorney, I'm held to a higher standard of ethics than most city employees. We have the rules of professional responsibility, and so the City Attorney's Office has to make its own independent determination that there are no conflicts, that not that there are no conflicts, but that that it's appropriate to waive my conflicts of interest and allow me to do this work on direct matters that I've worked on before with the city. The City Attorney's Office knows that the city's interests are not adverse to our nonprofit affordable housing developers, and that because of the unique nature of the work and the collaborative relationship, I did not possess any material confidential information that I could possibly use to my advantage. So the City Attorney's Office, who's held to a higher ethical standard, and me, who's held to a higher ethical standard, the City Attorney's Office already has determined that a waiver is appropriate here and has provided me with a conflict of interest waiver, which is in your packet, which was already approved by the City Attorney's Office. The Executive Director's report provides no explanation as to why the City Attorney's determination that a waiver is appropriate here is being second-guessed and is considered irrelevant. It's given absolutely no weight. And so I implore you to give weight to the City Attorney's determination and to the opinions and information shared by all the people who actually do this work every day and who will be most affected directly by my absence. The second point is, as the report itself points out, and as Deputy City Attorney Andrew Shen can confirm, over the past several years this Commission has okayed these same waivers many times, and in most cases with facts far less compelling than mine. The only time a waiver wasn't granted, it was not denied and not granted, was because the the waiver request was considered to be not right because the person didn't have a job already. The report provides absolutely no explanation as to why my request is so uniquely different from all of the waivers in the past years that have been granted. And in particular, in 2011, this commission granted the same waiver for a Deputy City Attorney, Thomas Long, on the basis that there was no potential for undue influence or unfair advantage because there was a general mutuality of interest between the city and his new employer. Significantly, the Executive Director's staff report in that case gave great weight to the fact that Mr. Long was an attorney and would still be required to obtain a conflict waiver from the City Attorney's Office. Well, in this case, I've already received that waiver from the City Attorney's Office. In Thomas Long's case, which got granted, he hadn't even gotten that yet, but it was still given great weight by the Commission. And in fact, I can quote it to you. It says, granting a waiver in this case, this is from the staff report, granting a waiver in this case would only help to streamline the procedures that Mr. Long must follow were he to communicate on behalf of his client on a matter that the city is a party or has a direct and substantial interest. For that reason, and because of the mutuality of interests, the staff believes that granting this waiver would not create the potential for undue influence or unfair advantage. And as you will hear from people that are supporting me here today, that there's that same general mutuality of interests between the nonprofit housing developers that I represent now and the city in the affordable housing world. To me, I mean, where the city attorney has already determined that the conflict waiver is appropriate, I don't know how that can be given zero deference, particularly where it was given great weight in that recent granting of the waiver. So I'll skip ahead now to get moving through it. The work that I'll be doing in my new firm, it's a small firm. There's 4 full-time attorneys, including myself, 2 part-time attorneys. All of our clients are nonprofit affordable housing developers throughout California. That's the only people that we represent. All of the work that we'll do is transactional. We don't go before committees. We don't represent them at proceedings. We don't do litigation, just transactional work. We help them with all the legal work related to the financing and real estate aspects of affordable housing. That's all we do. As you know, there's an affordable housing crisis in this state and especially in this city. Now more than ever, we need all the resources we can get to deal with this crisis. It's complex work. It's challenging work. There are not a lot of people that do it. And I've been doing it now for over 10 years and am considered somebody who is fairly knowledgeable and an expert in the field. One of the reasons I was offered this job is because it's very hard to find people that do this kind of work, the affordable housing legal work in this country, but certainly in the state and in the city. If you deny my request, you're putting someone who has a lot of experience permanently on the sidelines with respect to all the significant affordable housing projects that are coming up in the city, because I've worked here for 8 years. I've been the only person doing all of the legal work for the Mayor's Office of Housing. I have touched every one of those projects. So every project that's coming up now, all of the redevelopment of the public housing sites, every Mission Bay, everything, Trans Bay, Hunters Point, every affordable housing project is something I would not be able to work on. And you'd be taking that away from the city, from the affordable housing community, and from me personally. So again, you'll hear from some other people about how the affordable housing community is on both the private and public side, a small, tight-knit family. We're all in this together with common goals and shared interests. We collaborate and treat each other as partners on the city side and on the nonprofit affordable housing side. Everybody moves around, changes organizations interchangeably. Doug Shoemaker, who was the Mayor's Office of Housing Director for the last few years, up until a few years ago, he's now the Executive Director of Mercy Housing California. Kate Hartley, who was a financial consultant to the nonprofits for a long time, now she's the Deputy Director of MoCD. Mara Blitzer, she worked at Tenderloin Neighborhood Development Corporation. So do most of the Mayor's Office of Housing project managers. They've all worked for the developers. They go back to the developers. Everybody, because it's a very specialized field of work, everybody stays in the field and everyone's dedicated to it and everybody moves around constantly. It's also really, really important that I say that, I don't have confidential information that would somehow be used to my client's advantage, as, again, shown by the fact that the city attorney's office made that same determination. As folks from the Mayor's Office of Housing can point out, this is it's just not how the city works with a nonprofit affordable housing developer. They don't hide information from each other. And as OCD Deputy Director Kate Hartley pointed out in her email sent earlier today, which I hope that you've seen and read, all of this work is subject to multiple layers of review by the public, by other government agencies. The public scrutiny on these deals is so great that there really isn't there's no confidential information that's hidden from it that wouldn't at some point be revealed anyway. The work we do is so transparent, it's so much in the full view of the public, that the likelihood that the public would perceive that I have some undue influence or unfair advantage is so small, especially when balanced against the public interest in having me work on these deals. It's not like I'm going from the planning department to go work for a for-profit developer. I'm trying to use city connections to make money or game the system, or going to work for some big corporate law firm and representing corporate interests. I'm just trying to continue to do the important work that I started here in the city. The Executive Director's report, again, with all due respect, provides no real analysis. It just makes conclusive statements based on a narrow reading of the ethics rules and gives no weight whatsoever to any of the points that I've raised. Ignoring all of these considerations and denying the waiver based simply on those conclusive statements would effectively be like writing the waivers out of the law. It would mean that there could never be a waiver because, in theory, you could always argue that there could be some potential appearance of undue influence. It's reading the rule in a way that I'm being punished personally, the city and the affordable housing community are being punished because I'm simply good at this work and I'm an expert and I have a lot of knowledge that I've gained. I just can't understand how that would happen. Anyway, to sum up, the truth is granting me this waiver would not create a potential for undue influence or an unfair advantage because there's nothing adverse about the relationship between the city and the nonprofit developer clients. And in fact, having the unique perspective that I've gained from representing the city should actually benefit the public interest and the advantages for the city because it would allow me to be a more effective problem solver as we work towards our common goals of building and preserving affordable housing. I'm just going to take one more minute and just tell you a little bit about me. My whole career, all I've cared about is affordable housing. In law school in D.C., I spent my entire last year helping low-income tenants purchase their building to prevent it from being converted to market-rate condos. I spent 3 years here representing nonprofit developers before coming to the city attorney's office. I came to the city attorney's office not to be a city attorney, not to be a politician, but to do affordable housing work for San Francisco. It's the specific position that I applied for and that I wanted to do. It's all I wanted to do. I just wanted to help get affordable housing built here in San Francisco. My dad, in fact, made fun of me and said that I'm the only professional that he knew who deliberately kept choosing jobs that paid less than the job that I had before.
Is that true this time too?
No, it's not true this time. But when I was offered this new job opportunity, it wasn't about money. And you can ask anybody here. I struggled deeply with the decision, and I spent weeks of not sleeping because I love this job. I love the job that I had here. I absolutely loved it.
If we were to grant this waiver and say a few months from now, you received an offer from a big corporate firm giving you a lot of money, very tempting.
Nope. Sorry.
Haven't finished.
Sorry.
And you, as is your right, as someone who's a professional and wants to move up in the world, might have family needs, other types of things. Well, I'm going to take that job. Let's say you made that decision. what would be the effect of our waiver then? Would the waiver be off?
Don't grant me a blanket waiver. Grant me a waiver to do this very specific work at this very specific firm for nonprofit affordable housing developers. That is fine with me. I don't have any problem with that because I know this is the only job that I will have, and if I don't have this job, I will have another job in the affordable housing world. This is what my life is dedicated to. I truly did not make any decision in my professional career, including this one, about money. The reason that I took this job, that this opportunity was given to me, is because I felt after weeks of hemming and hawing about it and really struggling, that it was an opportunity for me to make a larger impact throughout the entire state of California. And more importantly, and I can't emphasize this enough, the deciding factor for me was the belief, after talking with the city attorney's office about it and the mayor's office of housing and knowing they would support me, that I would be able to continue to do all of the work here in San Francisco. I can honestly tell you that I do not think I would have taken this job if I knew that you guys would deny this waiver for me. Because I have put my blood, sweat, and tears in the last 8 years towards doing this work here in San Francisco, and I've just sat here and watched as things have gotten worse here in San Francisco, and there's so much going on now, and there's so much that I've put into that is just in the early stages that I can't even imagine not being able to work on those projects. And the idea that I would be denied the opportunity to do that? Anyway, sorry.
When you took the position at the city attorney's office, you were aware, were you not, of the one-year prohibition?
Yes.
Dealing with the city?
Yes.
And there are two exemptions you're asking for. One is the one that would be a permanent,
yes,
which is where you were directly working on something, now you're going to the other side and working on something, and you're saying, no, they aren't really on the other side. We're all one big family. I guess the Code of Professional Ethics is very clear that it's a non-waivable conflict if you are representing a client and you go to the other side and represent a client.
Can I ask Andrew Shen to maybe say something about that?
Sure.
Sure. Let me just make a very brief exclamation. So just to confirm, as Mr. Gross said, my office has granted him a professional responsibility waiver to continue his work for his clients at Governmental. It is a waivable conflict under the rules of professional responsibility of California, and we believe our waiver was completely appropriate.
You're saying that under your interpretation of the rules of professional conduct, that a lawyer can be on one side and then go to the other side and represent them in the same matter, and it's waivable?
Yes, it is a waivable conflict, and we granted a waiver to that effect.
I don't agree with that. As someone who teaches professional responsibility in law school and have taught it over the course of the last 15 years, that would be ever waivable in terms of a lawyer for one party then going in the same matter over and being a lawyer for the other party. You're simply totally wrong when you say that's waivable. That's one of the complete mortal sins of conflict of interest. You're wrong.
Actually, Commissioner, I'm not incorrect at all. It is a waivable conflict on the rules of professional responsibility. There's nothing in there that prohibits switching sides in the manner that Mr. Gross is asking a waiver from the request from. Certainly, if you have doubts about my view of the law concerning legal ethics, I'm happy to provide you with written advice on this subject if you want to continue this matter. But certainly, I know of no authority that imposes such a broad rule as I suppose that you and Commissioner Rennie seem to believe exists.
So if there's litigation going on now in regard to the city in which the city is involved, in which Mr. Gross is an advocate on behalf of the city in that litigation. He's directly involved in that litigation. And we get this waiver, and he then goes and joins in the other side in that litigation, just walks across to the other table in the courtroom, sits down and starts representing them. That's okay?
No, the key here, Commissioner Keene, is that my office has granted our consent to that arrangement. The conflicts of interest are subject to the client's consent and okay as to that switching sides as you described.
And the client here is not your office. The client are the people of the city and county of San Francisco. So the fact that you're the attorney for the people in the city and county of San Francisco, the fact that you're saying it's okay with you, I'm not talking about you personally, but your law office, it's okay with your law office that the client, the people of the city and county of San Francisco, have a lawyer on the other side who has a conflict of interest as to them in a particular piece of litigation, and that they are going to be harmed by it, that's all right because the lawyer says it is? That's nonsense.
So you're absolutely correct. Our client is the city and county of San Francisco, and on behalf of the city and county of San Francisco, my office does have the authority to consent to the waiver of a conflict of interest. As to this particular waiver, I can assure you, as you recognize, it did not stop at me. It certainly went all the way up the chain of command in my office.
Has it gone to the State Bar of California for an opinion as to whether or not what you would be doing would be ethical in order for you as a deputy city attorney in a piece of litigation where the city is being sued, the people of the city and county of San Francisco are involved in litigation, that would be ethical for you as a lawyer for that client to get up in the middle of the trial and say, well, I'm going across, I'm going to represent the other side. Have you gone to the State Bar of California and asked them whether or not it is something that is appropriate under the rules of professional conduct? I'm not talking about you asking people in your office. If people in your office have told you that, I'm telling you they're wrong. Have you gone to the State Bar of California?
Before he answers that, just one thing to point out. The waiver is not for litigation. I'm not a litigator. I'm not asking for that from you, or did I ask that from the city attorney? I've not done any litigation work in my entire career. I wouldn't know the first thing about it. That is not even something that our clients at our firm engage us in. We would never do litigation. We don't know how to do litigation. We're not litigators. We are simply transactional attorneys that only do real estate and financing transactions on affordable housing work. That is all we do, and that is what the waiver was granted for. And if you look at the waiver, they actually carved out, except for matters of litigation against the city. So, I would be perfectly fine with you carving that out. If litigation is your concern, I'm never going to do litigation in my entire life. So that is, I don't know if that makes a difference in this discussion that you're having, but I just wanted to point that out.
It's a lot more comforting than the general, totally wrong statement that was made here by the deputy city attorney, that kind of conflict, the lawyer could just give up any conflict on behalf of a client. That's nonsense.
Sure, and I understand.
So your statement is somewhat comforting.
Okay, yes. Thank you. And I do understand that litigation is a completely different matter, and I'm again happy for you guys to grant me a limited waiver that only allows me to do the transactional work on affordable housing projects for the nonprofit clients that we have.
The difficulty I'm having with it is the whole purpose of the 1-year requirement is the public's perception. Now, you're saying there isn't any showing that the city's going to be prejudiced or there's going to be undue influence. But the public's perception is here is a city attorney who's working on projects who says he's so valuable to the city. He said, but I'm going to go across the street and get more money with a private firm. I'm going to do the same work that I did with the city. But now, and it is the perception that the public has is that it's a revolving door. That somebody works for the city, they walk out and they ask the Ethics Commission, give us a waiver so we can keep on doing what we're doing, rather than saying, hey, we're going to say, when you took the job, you knew there was this requirement of a 1-year waiting period, all right? And now you're asking us that there's some reason why we should waive that requirement when the perception is that what you're bringing to your firm is your expertise that you gained at the city's expense.
At the city's expense? I'm not so sure at the city's expense, but...
They paid you.
Okay. So there's a few things in there that I do understand. I think if you want to read, I provided all the reasons why I think that the waiver should be granted. If you want to read the ethics rule in the narrowest of senses, you're absolutely correct. If there's a perception there, then you shouldn't grant that waiver. However, the waiver is there for a reason. If you read it that narrowly, there will never, ever be a time that you could ever grant a waiver like that, because there's always going to be a theoretical perception when somebody goes from the city to private practice to do the same type of work that they're doing. I also think if you read it that way, to be honest, I mean, this is a larger conversation, but you're going to have a hard time recruiting people to come work in the city attorney's office if they think their area of expertise suddenly, by becoming experts, they're going to be punished from that. The 1-year waiver, I'm quite frankly, I'm a little less concerned about that. I don't want there to be a 1-year cooling off period. I would like to be able to conduct business with the city attorney's office and help them, because there are a lot of crucial projects, including what you will hear from some folks here from the Mayor's Office of Housing, the Rental Assistance Demonstration, the RAD program, which is happening in the next 6 months, and is work that I've been working hard on, harder than anything else in my entire life for the last 2 years. That work is being finished over the next 6 months. I would like to be able to continue to work on that. But quite frankly, I'm less concerned about that than I am about the permanent ban from doing the work, because again, I worked here for 8 years, and affordable housing projects, they take, as you can imagine, a very long time to go from inception to completion. Many, many years. There are projects that when I came in to the city over 8 years ago, we were talking about them, and today we're still talking about them, and we haven't even started the work yet. I would be unable to do any real affordable housing work in San Francisco for the next 5 to 10 years at least, maybe even longer. Some of these projects are 15-year projects at least and haven't even started yet. So that's the thing I'm more concerned about, although I will say that I'm sure the city attorney's office, who supported this waiver, and if folks were here today to speak on behalf of them, they would I know that they are very concerned about my not being able to communicate with them because of my expertise and my ability to problem solve on these complex issues. They need my help on that. And I will say, from being on both sides of it, that it really is, I know it's hard to believe when you don't actually practice in this particular very specialized area, but it really is a partnership. It's not an adverse relationship. You have to just look at it from a different context, from a different perspective, and understand that the work that we do, we are striving for a common goal, which is to build affordable housing in San Francisco for lower-income families and for the public benefit. And that is our focus at the city attorney's office. That's our focus at the mayor's office of housing. That's our focus, the nonprofits, and that's our focus at my firm.
Commissioner Andrews.
Mr. Chair, Mr. Gross, you referenced in your presentation a waiver that the Commission granted in 2011.
Yes.
Ms. Pelham, do we know more about that, and under what justifications we use to grant that? Are there similarities, and in what ways are they different?
I think we do know a bit about it, and as Mr. Gross has indicated, I think correctly, we referenced it in the memo because there was an alignment. In short, there was an alignment, a mutuality of interest between the city and the organization that the former employee went to represent the city's interests before another body. I can't, short of that summary, I can't recall the details for you. I'd have to look at the actual, we'd have to dig into the actual memo that was provided to the Commission at that time. So I think the question here, it's a fair question about where the city's interests mutually align with another's, and I fully appreciate the collaborative nature of the work that Mr. Gross is doing and the importance of the work that he's doing. I think the challenge is setting aside those very worthy goals and looking to at least understand as a basis for your consideration, what is the purpose that post-employment lobbying restrictions or post-employment restrictions serve. I do think there's a distinction between a waiver on a legal basis and a different purpose that's served with the provisions that are in the law for post-employment restrictions. I think one of the things that I would just want to insert into the conversation as well, in terms of the permanent ban, the language of the ordinance talks about a permanent ban as it relates to particular matters. And I think one of the areas of difficulty we have at the moment is understanding, for all of the list and litany of projects that Mr. Gross worked on, are there within that list some matters that in fact have concluded which would permit him to work on those other matters even if they relate to the same project. So it's a bit of a nuanced question, and I don't know that we have actually full information. Perhaps Mr. Gross can enlighten us on that. But the intent certainly of the permanent ban is to not prevent somebody's gainful employment with their expertise, but to restrict that revolving door on direct matters where they had a direct personal involvement in a substantial way while working directly for the taxpayers as a public servant.
Rennie?
Sure.
Ms. Pelham, but why isn't it compelling that the city attorney and the entity that Mr. Gross was advising have both waived the conflict, and the entity that he was advising has gone so far as to affirmatively state that it would be so beneficial for him to be involved?
Well, I think those are factors that should be given weight in your consideration. I think the distinction that I was attempting to make at this, in my recommendation, is that there still is a potential that when an employee who's been in public service moves to private sector employment and is being paid by a private sector organization to come back and shape those governmental decisions, there always is the potential to have a conflict, not a legal conflict of interest, but the potential that his or her former colleagues may be unduly influenced because of if they're there within a year cooling off period,
but if
or if they were so involved in a matter that might carry undue weight in the discussion. And I think the other question is the undue influence or undue access that the new employer may have. There may have been a number of employers, potential employers for somebody who wish to hire somebody with Mr. Gross's expertise, but they're not a part of the mix. If
I completely get that, but if you are the client and you affirmatively make a waiver, and the client in fact says, we really need this guy, I mean, why then so much risk of undue influence? I mean, the client presumably has its own best interest in mind. It doesn't care about Mr. Gross. The client cares about itself. And if the client is going out and affirmatively saying it's okay, you need to let him do this, that does seem compelling to me. Now, whether that results in waiving the 1-year ban, I'm not sure. But my concern about this undue influence is certainly lessened if in a situation like that, because I can't understand why the client would waive otherwise. But if anybody has other information about that, I'm all ears.
Well, I just wonder if we couldn't get a little more explanation about how in the low-cost housing area the city and the nonprofit developers work together. I mean, I do know that it is a very special area, and where both parts, the community and the city, are working together. so that essentially everybody's on the same side. There are technicalities that have to be addressed, and perhaps that's the role that you're playing by moving over to the nonprofit sector. I don't know, but perhaps the director of the Mayor's Office of Housing could enlighten us a little bit on that.
Yeah, and not just him, but everybody, half the people at the Mayor's Office of Housing is here, as well as some of the more prominent affordable housing developers from San Francisco. And
well, I'm sure that if the director of the Mayor's Office can't explain it, I don't know who else could.
I would be more than happy to cede the microphone.
Thank you, Evan. Olson Lee, I'm the director of the Mayor's Office of Housing. I've been the director of the Mayor's Office of Housing for the past 5 years, so I am the employer of Mr. Gross. I am his client. I've been in the city for 25 years. I'm working in the field of affordable housing. I haven't gone from one side to the other. I've just worked on affordable housing because I believe in affordable housing as passionately as Evan does. I think the question that you all raise is there indeed a conflict? And from our standpoint, it's the question of the mutual interest that some of the commissioners have raised. We have a very unique system of building affordable housing in San Francisco. We have a lot of repeat nonprofit developers. We work with them over extended periods of time. We've worked with some of the developers behind us for over 30 years. And we've established a relationship of cooperation and mutual self-interest that we're all in it together. We're not going to screw each other. Because we're going to have to work with each other anyway. And so we go through this process of being extremely transparent and really working for our own best interests. And what the law firm that Mr. Gross is going to work at, what they also do is working also for the city's best interest because they negotiate with the investors in our affordable housing. They try to get the best possible deal on behalf of their developer clients, which also means that I pay less in terms of the gap financing for our affordable housing. We share that absolute goal of building affordable housing because the developers don't often find the projects by themselves. The developers find the projects through either our RFP for a specific site where we've already decided what we're going to build. There's not a negotiation about whether they're going to build affordable housing. It's a requirement. There's not a discussion about what the developer fee is. That's already been set. There's not a discussion about how we're going to underwrite the transaction. We have underwriting criteria that the developers and the lenders have to meet. Because of the unique nature of this, because we've been doing this for such a long time, we've had to build all these set procedures where basically, it's plug and play. The developers come in, they know that these are the requirements. There's a little negotiations on the edges with the lenders and investors, but again, it's to get the best possible rate, the best possible terms for the developer in terms of reserve requirements and things like that, which also then again benefits the city because the city doesn't have to put up those additional reserves. So there is an incredible mutual interest between our developers and the city. We need the developers to go out and make this housing happen. We need the developers to stay in business for the extended period of time because if they go out of business during the period of the regulatory agreement, it's the responsibility of the city as the backstop lender because we're the lenders of last resort, and we also have in most of these cases, the underlying ground lease and the goal of keeping whatever our developer partners produce as affordable housing pretty much in perpetuity. So there is this incredible commonality of interest that we all work together and we all try to beat up the lenders and investors and the contractors, to the benefit of the city overall. For the developers to be successful, we have to make sure that the buildings are financially feasible. But all that underwriting is generally done in terms of what the city would accept, under what terms prior to the developer coming into the transaction and their attorneys coming into their transaction. So, and much of this information, because of the long time we've worked with all these developers, is very, very public. You can go to any of our transactions and look at what we've asked, what the developer fees were, what the percentage of the cash flow was, what the type of reserves that we allow in any building. It's very, very, very transparent. There's no confidential information in those particular transactions. And in fact, we often go to the board of supervisors, to issue bonds, and we talk, entirely about what the structure of the transaction is, prior to actually closing the transaction with the individual developer. The transactional work, the actual closing of the loan with the city and the ground lease and all that stuff and the bond documents happens at the tail end. And we're in front of the other public bodies, whether it's the loan committee or whether it's the board of supervisors, and we have a level of public scrutiny on those transactions, on those developers, on the mayor's office of housing, that would highlight any conflict of interest. If anything falls out of the norm, the question at these public bodies will be, why? What's so different about this particular transaction? And it's not going to be because Evan Gross happens to be the attorney on this particular transaction or not. I don't think that anybody in the affordable housing field would say I play favorites. And it's really been the role of the mayor's office of housing to really be standard operating procedure for everybody, because that's the safest. That's the safest way we've done our business, whether it's any particular developer, any particular attorney, any particular contractor, lender, or investor. It's the standard operating procedure for everybody, because that is the only way we are successful in doing our work and really maintaining the integrity of the program overall. So when Evan asked us whether we would sign on to the waiver, I said yes, because of this mutual interest and the mutual goal of building and preserving affordable housing. I would say to Evan that he probably got smarter over the years that we were working together and has learned more about affordable housing development, and in part because we have this mutual self-interest along with the developers and their counsel. We want them to be the smartest developers possible. We want their counsel to be the smartest counsel possible, because we're all working together.
But there's so many lawyers. I mean, why do you need him?
There's not that many. Well, I won't say anything about how good lawyers or bad lawyers, but there's not that many lawyers in this specific field. His firm has been in the affordable housing field. But you
already are using his firm. Other members of the firm, right?
Well, I think the part of it is the size of the firm and the capacity of the firm. So this firm started in the field of affordable housing before there was a low-income housing tax credit. So they were doing syndications in the early 80s or mid 80s, and they've followed this field during this whole period of time. They have 3 lawyers. It's not a big firm. They're all really stretched trying to do the work that they were set up to do. They only do affordable housing. They just only do affordable housing. They won't even do affordable housing for-profit developers. They only do affordable housing for nonprofit developers. And that's why we feel comfortable in terms of doing the waiver. Having more information, more expertise on the other side doesn't hurt us. It helps us. And we're not afraid of it, because we have good attorneys. We have good attorneys, and we have a good staff, and we have a structure that that basically has created frameworks for all of our transactions. So we don't feel that there's going to be any sort of conflict as we go through this process, because the attorneys from the other side are not involved as we set the policies, as we set the underwriting. We talk with our developer partners about that, but it's not with a bunch of attorneys in the room lobbying us to give them the most favored nation status or anything along those lines. It's really about working together for this common goal. And I would also say we are, as we are in a time when my office can't build enough affordable housing fast enough. And whenever I go to any public meeting, it's about, why haven't you built it already? And so what we're saying is, you know, and actually, you know, I'll be perfectly honest, the loss of Evan from the office is a big loss. The fact that he'll be on the other side mitigates that in some respects, because he's taking that expertise to help, again, move the process along so I can close my big deals, you know, my public housing rebuild, my other transactions. And I don't feel that I'm going to be at risk of having, you know, somebody on the other side know something, you know, sort of secret about my, you know, structures or strategies, in part because we've been so transparent about what we do already. You know, there's no secret sauce to what we do. It's just a lot of hard work. So we would plead to this commission that this waiver not only would help my ability, because I am going to be judged on really on not whether, you know, Evan works for the city attorney or works for this other firm. I'm judged on really my ability to get housing done. And I've supported this waiver in part because I think it would be helpful to my goal of getting affordable housing done. Thank you.
Commissioner Keene.
This is really unique, and it cries out with a lot of equities. There's no question about it. But let me ask you this. I mean, you say that everything's transparent, and everybody, he knows what's in your mind at all times by virtue of what he's been doing for you now. When he moves to the other side, you're still in a negotiating situation with the other side. No matter how much both sides might love each other, you are still negotiating on behalf of the city to get the best deal for the city, correct?
Yes, but
let me I'm not finished. Okay. So now you're negotiating with someone who's got your family jewels, who's been with you and knows all of your tactics. I'm not saying there's anything nefarious or anything like that. But you negotiate, rather than negotiating at arm's length, you're negotiating with someone who has all of your strategies, your tactics, the way you play your cards, knows everything about them. On behalf of someone who's doing something, who's trying to get something from the city, a particular contract from the city. Aren't you at a disadvantage negotiating with someone like that than you would be just with someone at arm's length who doesn't know all of this information, strategy, tactics that you have? And they're being at a disadvantage then, isn't the city at a disadvantage because they're not going to make the best deal in every respect not because you're going to get your pocket picked or anything like that, or anything dishonest is going to, but it's not an arm's length negotiation, even in the transaction. Isn't that true?
Well, let me put it in context. So I talked a little bit about the structure in which the transactions occur. So we're not going to be negotiating about the bond issuer fee. We're not going to be negotiating about developer fee, about cash flow, about the underwriting requirements, or all those other things that we would typically negotiate, what the city might negotiate with a private developer, because those are set, because we are the lender of last resort, and we're going to set those terms. So there's not as much negotiation that goes on. I would think that in some respects, Evan, having experienced my decision making about what I like and what I don't like, I think simplifies the negotiations with the developers. They will clearly not bring to me what I don't like, because Evan will know that I'm consistent in my decisions, and if I've said no before, I'm likely, very, very likely, to say no again, because I want to be very consistent in my decision making. So in some respects, it helps me, because I don't get, stuff from a new attorney who wants to break new grounds, who hasn't worked in San Francisco, and says, well, I worked with so-and-so in Santa Clara County, and we negotiated the developer fee, and I have to go through the, hi, welcome to San Francisco. We have this system here. Let's talk about how your client may fit into this system because this is our structure. So in some respects, there's both sides of it. That he does know the system, which is actually a good because it facilitates our discussions with the other side. He does know sort of my decision making on certain policy issues, but again, that facilitates moving to yes as opposed to butting heads with a brand new counsel from God knows where, and who may or may not have the experience working in the city of San Francisco. The city of San Francisco affordable housing community and the work that we do is pretty unique around the state. There is no other city that supports the affordable housing in the manner that the city and county of San Francisco does. There is no other city in the state that has their hands on the transactions as much as the city does, as at the staff level, not at the attorney level. We don't leave it for the attorneys to negotiate the transactions, but the principals in my office, my staff, who are here as independent individuals, not on time, but they are the people who negotiate these transactions, and we don't rely on the attorneys for negotiating the transactions. The attorneys will be there to document it, make sure we're doing it right, but the attorneys are not leading the transactions. The principals understand the business points and negotiate that.
Attorneys are advising the principals, aren't they?
The attorneys are advising, but
in terms of the attorney advising the principals, if that attorney knows what your cards are that you're holding, then the principal is going to know what's in your cards, right?
Well, I think my cards are pretty as I said, my cards are very, very transparent. In terms of what we do as an office, what we have done in the past, it's pretty transparent to not only to Evan, but to any outside counsel who actually takes the time to understand what San Francisco does.
Any other commissioner have any questions? At this time, I will ask for public comment.
Thank you, Commissioner Rennie. I'm Patrick Manetsaw, and for over a year I've been trying to work with the Mayor's Office of Housing and Community Development to obtain data regarding their down payment loan assistance program, particularly an investment that they're trying to pawn off on the San Francisco retirement system. And I can tell you, they are not transparent. I've had to pull teeth with both the San Francisco ERS and with MOHCD on getting basic Excel spreadsheets. I can't get them. I get them in PDF. They're incomplete. Their data sets are a mess. Mr. Gross says they don't hide information, and their public scrutiny is great. And Mr. Gross and Mr. Olson Lee say that they are completely transparent. I don't agree with them. I don't think you should agree with them either. It smells. People are already concerned about the undue influence the nonprofit sector has on the affordable housing that gets built in this town. I think I can help Ms. Pelham out. I believe the last time you heard a post-employment waiver request at the Ethics Commission was with former Supervisor Tony Hall, I think in 2011. I advised him, don't do it, because if you go to TITA and you got 7 kids to put through school, it ain't going to take long before the mayor gets you forced out of TITA, with or without a waiver. And guess what? I was right. Attorney Hall lost that job really rapidly. You made one mistake, granting a post-employment waiver. Don't make another one.
Thank you.
Commissioners Ray Hartz, Director, San Francisco Open Government. I'd like to first say my understanding of the Deputy City Attorney's recommendation and use Member Keene's example of the court case. I would suppose if I was a client, a participant in a court case, and my attorney said to me, Mr. Hartz, I would like to quit representing you and go represent the other side. Is that okay with you? Technically, I guess I could tell him to, yeah, okay, no problem. Would I? No, I am not an idiot. So basically, that argument makes no sense at all. I don't want my attorney who knows everything about my side of the case to go to the other side. As far as this idea that we're all in this, we're one big happy family, that's a bunch of crap. Bottom line is the mayor's office doesn't agree with the Board of Supervisors on affordable housing. They have significant difference, and I can see the mayor's office wanting him to go to work for these companies, because then the mayor's point of view will be given to those people, and the other members of the city government who might have different point of views will not. I think it is also unfair to the people who would be hiring him. There are a lot of nonprofits in the city, and now we're going to talk about 4 nonprofits, I think it is. They're going to have access to information that none of the other nonprofits who are competing in the open market for city dollars, and they will have an advantage over those other nonprofits because they will know ways to talk about things, where they will know how to phrase them. They will know how to put it in a certain way so that the commission or whatever knows who to talk to, who to aim at, which member of the commission is in our favor, and how can we give them the ammunition to fight on our behalf. In the private sector, they have a non-compete agreement, and everybody understands a non-compete agreement, and if you sign one, it's a done deal. And it is to protect proprietary information and everything else that goes along with that. Allowing a deputy city attorney who knows all about the city's position to go work for somebody who is negotiating, as Mr. Keene said, with the city is just a nonsensical thing. It is something that nobody who has their own self-interest in mind would be willing to agree with.
Thank you.
I still have 30 seconds. The public does look at these things, and I've been coming here for years, and I've watched waivers be granted, and I looked at it and I thought, what is going on here? You sign a waiver when you take the job. Is it a condition of your employment? And now you're coming in and saying, don't make me do what I agreed to do in the first place. Mr. Gross agreed to follow these rules, and don't exempt him.
Thank you.
Good evening, Commissioners. My name is Whitney Jones. I'm the Director of Housing Development for Chinatown Community Development Center. In response to the housing crisis, the City of San Francisco has taken on 2 momentous tasks: trying to deliver 10,000 units of affordable housing by 2020, and within that, trying to transfer 3,500 units of public housing to nonprofit housing developers. Both are really important challenges, and both are straining the affordable housing resources, particularly human power and expertise of the city and the practitioners within the city. Evan Gross is an important resource in that effort, one of a handful, and it's a small handful, of people able to do this work. And the work isn't adversarial or collegial or filled with secrets. Adversarial or filled with secrets. It's collegial, as witnessed by the fact that both my nonprofit colleagues, raise your hands, and my city adversaries, raise your hands, are here in support of Mr. Gross. We urge you to waive the restrictions and let him practice immediately. Thank you.
Thank you.
Good evening, Commissioners. I'm Barbara Gualco, and I'm the Director of Housing Development for Mercy Housing. We own over 3,000 units in San Francisco, with currently hoping to start construction on 200 new units, as well as all the RAD worker involved. The need for housing is staggering, as we recently received over 5,000 applications for 70 affordable units in Trans Bay. Mercy is a very strong supporter of Evan Gross's request for a waiver. We desperately need legal talent as Evans to help us finance and develop affordable homes. Our work is pretty specialized. Partnership and collaboration, which you've heard a lot of, is really the way we get it done. I wish we could negotiate more, but really, with the amount of sort of free money we need to put together in order to build affordable homes, both at the state and federal level, what we really do is problem solve. We really problem solve. We work together to try to figure out how that new rule that said we had to spend this much money by this much date, or have the housing built by this date, or you can't use this money for that use. We sit around and we figure out how to get it done. It's really not a negotiation. It's really about following the most unbelievable set of rules and regulations that govern our funding, as you can imagine. Very different from the for-profit affordable housing development. So we really need Evan. There really is a handful of great legal expertise that knows how all the federal funds, the HCD, MHP funds, the TOD funds, the Section 202 funds, the Prop A funds, all work together. So I really implore you to please grant him this waiver. We really hope to start construction on 200 units this year, but we really need his help to do it. Thank you very much.
Good evening, Commissioners. My name is David Schnur. I'm the Director of Real Estate Development for Community Housing Partnership, and I also request that you grant the waivers that will allow Evan Gross to continue doing this work for Government Barchet. Community Housing Partnership has a 25-year history of developing supportive housing here in San Francisco for formerly homeless people, and we are part of the group of nonprofits working to transform public housing through the Rental Assistance Demonstration Program. There is a lot of housing development activity in the affordable housing world in San Francisco right now, with the passage of Prop A, creating a new affordable housing bond, with all of the public housing revitalization going on. There is a lot of work, and as a previous person has commented, not enough bodies to do the work. We are pressed at every stage of the process to find enough people with the specialized knowledge to make sure all of this work can move forward. And Evan Gross is part of that specialized body of knowledge. We are excited by the prospect of having him be able to understand the city's perspectives as we work on the loan documents, the transactional documents, the lease agreements, and so forth, because it is indeed a cooperative process. We rely on the partnership that we have with the city to fulfill our mission. They rely on the partnership they have with us to fulfill their mission. Our missions indeed are very similar. I think any of the organizations here could state our mission statements, and they would sound very similar to the Mayor's Office of Housing and Community Development's mission statement, because we are all working towards the same goal, to create affordable housing for San Franciscans. I understand that the city's conflict of interest policy is intended to protect the city's interest and protect the appearance of the city's interest, but I think in this case, failing to grant the waiver would actually harm the city's interest, because we need as much knowledge as we have right now to address the critical affordability problems that San Francisco faces, and therefore I request that the city grant the waiver to Evan. Thank you.
Good evening, Commissioners. My name is Sharon Kristen. I work with Mercy Housing California as a project manager. As Barbara mentioned, Mercy supports Evan Gross's request that the Commission waive the suggestion or requirement that he not work on San Francisco projects for 1 year. I've worked with Evan for 10 years now. Barbara encouraged me to share an example of how Evan has worked with us and sort of represented the city's interests in working with Mercy on projects. We worked on a project at 6th and Howard Streets, the building where the furniture used to be hanging on the outside of it. That building had HUD financing, a city ground lease, state financing. HUD worked very closely with us to help HUD understand the city's ground lease and the city's ground lease requirements, and really helped us negotiate and make HUD comfortable with the ground lease, which HUD is not usually comfortable with ground leases. So Barbara mentioned, or Evan mentioned, that Episcopal Community Services, Tie-Dye, St. Anthony Foundation have all expressed support and worked with Evan on his previous projects. And I know you're aware of the critical housing crisis. I really hope that you'll be able to consider this waiver he's requested, because I think it would help serve the people of San Francisco right now. Thank you.
Thank you.
Bye-bye.
Good evening, Commissioners. My name is Benjamin McCloskey, and I'm the Deputy Director for Finance and Administration for the Mayor's Office of Housing and Community Development. I strongly support Mr. Gross's request for waivers from post-employment restrictions. As others have said, this waiver request should be approved due to the unique nature of affordable housing in the Bay Area and specifically San Francisco. This is not a traditional adversarial relationship. Additionally, affordable housing field is very, very specialized, requiring years of work experience to fully understand. It's imperative that the city be able to hire experts in the field and also to let them leave when it is time. The best candidate to replace Mr. Gross in the city attorney's office would be someone with a depth of experience in this field. If city employees are not allowed to leave city employment to work in other parts of the San Francisco affordable housing sector, our ability to recruit the best and the brightest will be severely hampered. Not approving this waiver will have a chilling effect on our ability to recruit not just housing attorneys, but also housing development employees for our office. The standard for approving the waiver is that the Commission must determine that granting the waiver does not create a potential for undue influence or unfair advantage. This standard is met in this case. I urge you to approve Mr. Gross's waiver requests.
Can I ask you a question?
Yes, sir.
When it comes to deciding who is going to get the contract to do the affordable housing, you talked about there's Mercy and there's Tenderloin neighborhood. Is that competitive?
It is competitive, yes, sir.
And was Mr. Gross involved in that kind of?
The attorneys are not involved in the competitive process.
All right. Thank you.
Sorry, can I ask a follow-up to that?
No.
But certainly having Mr. Gross as their attorney is a competitive advantage in a competitive process, even if Mr. Gross is not.
I'm not sure that the attorneys are, the type of work that the attorneys do in this firm are in any way really related to how a nonprofit would respond, but my boss can elaborate more.
Who their attorneys are not a scoring factor in our selection of the of a proposal. It's about the quality of the design. It's about the numbers of units. It's about the cost. It's about the fact that they're qualified to be, for low-income housing tax credits. And we never identify who their attorneys are as part of a request for proposal, nor do we score that.
If you don't mind, can I also just say that with respect to that, our firm doesn't actually get engaged on projects until after they've been awarded the projects. We don't do any of the work on that at that level, at the early stages. The nonprofits, once they actually are awarded a project and they know that there's going to be a project, that's when they engage our because we only do the transactional work to actually do the projects.
Mr. Gross, I just wanted to ask a clarifying question.
Sure.
Would there be an opportunity for any of the affordable housing providers during that RFP process to hire you so that you would consult with them as they write their proposal in whatever key area you could provide expertise?
I suppose theoretically, but I've never heard of such a thing happening, nor do I know how our legal expertise would have any bearing on, like Olson was saying, that that RFP process, whatever goes into that, is really about the design and of the project and the other factors that I don't even know, because again, as the city attorney, I wasn't involved in that process. So I have no idea what in that process an attorney would be able to provide in terms of, especially me, because I didn't even do that stuff at the cities.
Well, that's kind of my point. Because you didn't do that at the city, and as comprehensive as RFPs can be, particularly on these complex projects, there's probably some section in there that wants to hear from soup to nuts how it's going to go from conceptual to ultimately being built, and there could potentially be some reference that would discuss some legal matters that they may need to create a methodology around, a particular rationale around. Again, I'm not a part of the RFP process. You're not a part of the RFP process. But the fact is there's an X factor there. We don't necessarily know what those RFPs are requiring of them in terms of their response. But there's nothing that would preclude any of them to hire you to give counsel to them.
I suppose not, but again, I don't know what counsel I would provide in that situation. And I think that folks from the Mayor's Office of Housing can provide more illumination as to what goes into those RFPs, but I don't think that it's the kind of thing that where it would matter whether or not I was consulting with them, nor, again, in the 22 years of my firm's business, I can pretty much guarantee you that there isn't a single time that they were consulted with on that kind of process.
I'll hear more public comment.
Hello, Commissioners. My name is Faith Kirkpatrick. I'm a project manager at the Mayor's Office of Housing and Community Development. I'm here today in support of Evan's requests. I've worked in the affordable housing field for 10 years. I worked at a developer before. I worked for one of those tax credit investors, and now I work at the city. And I just want to echo what my other colleagues have said about the nature of our industry is very transparent and highly regulated. So I think I understand all your questions. They seem like good ones. They just don't seem appropriate to our industry. There's just not a lot of influence that Evan would have in contracts and getting awards. It's just not how we work. I don't want to diminish the work that he does, but it's about closing deals so that we can start construction and get things built, making sure the I's are dotted and the T's are crossed. I will give you an example. Mostly it's the tax credit investors who want to put something in the deal that doesn't benefit the developers and actually doesn't benefit the city as well. They'll want to exit a partnership after the compliance period and take a bunch of money with them. And so we'll say, no, the city doesn't want that. Actually, the developers don't want that either. So we're mutually aligned in a lot of those ways. So for those reasons, I support the waiver. Thank you.
Thank you.
Members of the Commission, my name is Mara Blitzer, and I'm the Director of Housing Development at the Mayor's Office of Housing and Community Development. I'm also a resident of San Francisco, and I've been in the field of affordable housing development for, I was thinking about, but more than 15, less than 20, 17 years, I think, at this point. And I'm here to support Evan's request for the 2 waivers, and I'd like to explain one of the reasons why I think you should do that. I also wanted to make the point, I have prepared comments, but it occurs to me that with respect to the development of affordable housing and this discussion about whether there's different sides, I think it's important to remember that what we're doing here is we are developing affordable housing for low-income people, and in that respect, we are quite mutually aligned. It's also the case that you can no longer build affordable housing without what we sometimes jokingly call a layer cake or a lasagna of other funders that includes the city, but also likely includes a private bank and a tax credit investor like Faith mentioned. And it's with those other parties that both the nonprofit sponsor and the city of San Francisco are very aligned in looking into the best interest of the people who will live in the buildings in the future. I think it's important for us to remember that. So we're mutually looking to build high-quality affordable housing. We're mutually looking to serve low-income people, and we're looking to create the best possible deal that uses the least amount of local city and county of San Francisco subsidy so that we can use whatever is left over to build the next. We have thousands and thousands of units in the pipeline, and we need people like Evan to be working with us in partnership, supporting our amazing group of nonprofit affordable housing developers so that we can meet our tremendous need here in San Francisco. So hope that you will consider granting those waivers tonight. Thank you.
Thank you.
Good evening, Commissioners. I'm Robert Van Ravensway. I was on the 2013-14 civil grand jury, and we had concerns about the process where decisions like this were being made. I think you're confronting some of these problems right now. This is an important decision. It's got, it has kind of bad optics to it, because it involves city real property, use of bond proceeds, things of that nature. But it may be the details of what's going on here aren't so threatening. But this is not a popularity contest. It's not just a situation where people can come in and make assertions. Nothing's being said under oath. And you've got to weigh all these different things. What I'm hearing and what gives me concern, look, we elect the city attorney. I don't see anything signed by the city attorney here granting a waiver, just for one. The 1 year wait is pretty standard, and, people can still work on matters. It's just a matter of who you talk to. You talk to your clients, the clients talk to the city. There's somebody in between you and the city. It doesn't mean you're not doing work for the clients, but it can all work out. But I think the staff memo expresses some concern that they haven't had a lot of time to really look at the matters that are listed here. And there's a long list of existing matters that are attached to this waiver request. And as I hear people talk about the transparency of the process and things like that, it may well be it is transparent enough. It may well be that there isn't a lot of confidential information. It may well be that the work that he did or is doing on these matters really is all with public information, and there's no need for a lifetime bar. I think you're in a difficult position to have to make a decision right away on this, and I think maybe you want to get some more information about the lifetime ban kind of issues so that people can really sort it out. But I don't think you should just make a decision right now based on what you're hearing in this room. I think it's important that the staff take this through a process and that people know there's going to be a process like this in the future when waiver requests like this come up. I think you have the framework here for a very good process coming to a very clear decision, and I think you ought to use that opportunity. Thank you.
Thank you.
Good evening, Commissioners. Kevin Kitchingham. I'm a 15-year resident of Bernal Heights. I had the pleasure of being the housing director at Bernal Heights Neighborhood Center many years back, and I now actually work for the Mayor's Office of Housing as a project manager. I think that some of the criticisms you may have heard from previous speakers may be valid were it not this incredible team you see come out and support this effort. So I would ask you to grant the waiver to Mr. Gross for a number of reasons. You've heard a lot about transparency tonight. Affordable housing development terms are regulated by federal and state programs as well as our own. You heard Director Lee talk about the underwriting guidelines that we adhere to. Actually underwrite a lot of those deals. At no time is an attorney, and I got to tell you, I'm not interested really in hearing from an opposing attorney about developer fee, rents, compensation, any of the deal points that would actually be beneficial or in the developer's best interest. I want to hear what the developer has to say. So I can't imagine in the years that I've been doing this job that I've ever had an attorney exercise undue authority or undue influence over a deal, let alone an attorney of this caliber. And the city is really shooting itself in the foot to lose an attorney of this caliber with the legacy knowledge. And you're right to point out there are no other attorneys. Our field is incredibly small, incredibly specialized. I mentioned Mo does its own underwriting. I believe there are members on this commission that are involved on boards that actually are pursuing affordable housing development. And we do a lot to actually make sure that those deals are fully transparent and actually discussed at length with not only our internal loan committee, our internal peer review process, but as the director pointed out, we also have to take these deals back to the Board of Supervisors. So there's a lengthy public process that goes into analyzing any of these deals. So to make the connection that this attorney has somehow going to change the game is hyperbolic at best. I would say that there is no attorney that I've met that could influence the individual deal points, let alone this attorney. I desperately ask you to approve Mr. Gross's waiver. Thank you.
Good evening, Commissioners. My name is Lydia Ely, and I'm a Senior Project Manager at the Mayor's Office of Housing and Community Development. My job right now is to manage the urgent conversion of 3,500 dilapidated public housing units to nonprofit ownership and to avoid displacing very low-income senior and disabled San Franciscans. This project is called RAD, and it's rad. It enjoys national recognition, and it's a city priority for the dozen or so departments that are working on it. And I'm very proud to be a part of it. Our whole office is involved in this huge effort. Last year, we converted 14 of the 28 projects, and we're going to do another 14 this year. That's a lot of work for us. We work hard, but that's even a lot for us. And the workload has required us to act more efficiently and to cooperate even more closely with our key partners, the city's affordable housing developers. We have to work with them as we negotiate deal points with Bank of America, which is the project lender and investor for the entire portfolio. Our mutual goal with the developers is, as usual, decent, safe housing that is affordable for the long run. This is also the goal of the over 5,000 residents of these dilapidated units. A key reason for our success with RAD to date, and I hope in the future, is Evan Gross. In his capacity as city attorney, Evan authored and crafted most of the key elements of the RAD transaction on behalf of the city. He worked collegially to create sound financial structures that will guarantee protections for residents and affordability of these units for 99 years. He was able to do this because of his deep and broad knowledge of affordable housing finance and of the funding programs and government agencies that are regulating our work. While he's no longer a city attorney, Evan's highly specialized expertise on complex deals such as the RAD project is still absolutely critical. Locking out one of the best affordable housing lawyers in the country when we need him the most will make our difficult work even harder. Thank you.
Thank you.
Good evening, Commissioners. I'm Sophie Hayward, and while I am the Mayor's Office of Housing and Community Development's Director of Policy and Legislation, I'm here on my own time to speak in support for the waiver request made by Evan Gross. And I respect very much the role of this Commission in considering waivers, and particularly the time that you spend in considering special circumstances that may exist to justify requests such as these. It could go without saying, but I will say it. Evan is wildly scrupulous. It is almost beside the point. I hope that the comments that you've heard tonight have helped provide additional information for you and for the public about the specific role of Evan's work in affordable housing development, both in his previous position with the City Attorney's Office and in his current position. As Director Lee and many others have eloquently described, basically, when Evan's current clients get a good deal, the city also gets a good deal. We have our interests aligned, we have mutual interests, and the city pays less in gap financing for the development of affordable housing. Thank you.
Thank you.
Good evening, Commissioners. Kate Hartley. I'm the Deputy Director for Housing at the Mayor's Office of Housing and Community Development, and I'd also like to thank you for your time tonight. I actually feel remiss for not before now providing more of a framework about the unique aspects of our industry, which I'd like to reiterate. The majority of our financing for affordable housing development in San Francisco, it comes from low-income housing tax credits. We also layer in tax-exempt bonds. We layer in money from the state. We layer in money from the Federal Home Loan Bank, from CDBG sources at the federal level, and home. Each of those carries with it very strict requirements, so that by the time a developer comes to us with a financing plan and is requesting MoCD money, The developer fee has been set by those federal and state requirements. The cash flow has been determined. The occupancy standards are defined. The rents are already established. There literally is no room for an individual attorney to negotiate a better deal because we are all reliant on the funding from state and federal sources that is so restrictive. When we do make our loans, it's a very public process. The Citywide Loan Committee approves our underwriting guidelines so that the terms we put forth, as my boss, Director Lee, talked about, are already pre-established. Again, there's very little room to negotiate, in fact, no room. Where we really need great attorneys and where the mutuality of interest occurs most importantly is in the nonprofit developers' negotiations with conventional lenders and with tax credit investors. If they negotiate a good deal, it's a good deal for the city. We are allied in that because it reduces the amount of public funds that have to go into these projects. The question was asked, well, doesn't it put us at a disadvantage at the negotiating table with Evan on the other side of that table, knowing that how we work, what we think about, what our priorities are? The answer is emphatically no, we are not at a disadvantage because those terms are prescribed. It actually is so helpful to us because having someone who understands the regulatory labyrinth that we have to sort through and can help us get to our mutual goal faster and more efficiently, and that is the production of affordable housing, is a great benefit to the city and one we should not give up. Thank you.
Good evening. My name is Katie Lamont. I'm the Director of Housing Development for TNDC, and we provide supportive housing, family housing, and senior housing in the Tenderloin and other neighborhoods in San Francisco. I'm speaking in support of Evan Gross's waiver request, and I agree with the statements that he made, the MoCD Director Olson Lee made, and many others before me regarding the way that affordable housing developers partner with the city to realize shared goals of providing housing affordable to low-income people. I was struck by the example in the staff report of the Deputy City Attorney Long leaving the city to work for Turn. The facts are parallel here. The city and affordable housing developers have mutual interests in their advocacy for City of San Francisco affordable housing projects in transactions with the state of California, U.S. HUD, tax credit equity investors, and bank lenders on behalf of low-income people that need housing. An example of these mutual interests was mentioned earlier. The City of San Francisco requires a ground lease structure to preserve long-term affordability and create leverage for the city in future negotiations with other lenders and investors. This is a structure that's outside the norm, and the firm Governmental has helped both nonprofit developers and the city to develop lender and investor acceptance of this structure. This is just one example. When doing transactional work, both parties are better served when each side has knowledge and experience and the associated confidence and creativity to work together to solve problems. As Barbara Gualco mentioned, our job is basically problem solving. I appreciate that Governmental wants to develop the next generation of its firm's leadership. As someone earlier mentioned, they only have 3 attorneys. And San Francisco is a very particular place to work, and the current partners at Governmental have come to know and understand it well. This serves the city because there is a built-in understanding of its positions and alignment of goals. And as both Kate and Olson mentioned earlier, it's ultimately more efficient for everyone when we know the ground rules and operate within them. What I appreciate about Evan, Olson, Kate, and everyone I have interacted with at MoCD is that they really listen and they operate in a fair manner. Part of why I enjoy working in this field is that everyone in our development and financing team shares the mission of addressing the great need for affordable housing in our city so that we can preserve it as a diverse place for all kinds of people to live, and a will to solve problems as they arise. Witness the 14 RAD closings that happened in December. That was the result of the sheer force of will of literally hundreds of people. I urge you to please grant this waiver request, and I wanted to address briefly an earlier question about whether working with Evan Reeves or the firm Governmental poses a competitive advantage during the RFP stage. And I just would reiterate an earlier answer that no, it does not. Nearly every nonprofit developer in the city works with that firm, and really their focus is on how do we make the ground lease work, how do we make the commercial space work, and these are common questions and not special. And I thank you for your time.
Thank you.
My name is Tom Lauterbach. I'm a senior housing project manager at TNDC also, and I'm supporting Evan Gross's waiver request. The challenge, I don't think, is a negotiation between the city and the affordable housing developers. It's really between the city and the developers together with all the other regulatory agencies. I just spent the last 2 years working on the RAD projects, the Housing Authority conversions, and the real challenge came when all the legal documents are all being near finalized and HUD sort of shows up at the table, the permanent lender shows up at the table and starts saying, oh, we can't do these certain things. And Evan Gross was able to concretely provide specific examples and responses to their concerns that put those to rest as well as they could be. I think that in the city, this work, it's not confrontational. It's problem solving, and you've heard several of us use that phrase. I think eliminating Evan Gross from the pool of participants, including and probably especially the RAD projects in this next year, eliminates a very valuable legal resource to the city and the developers. Thank you.
I'm Bob Plantold. I'm a beneficiary of affordable housing, but also when I was on ethics, I did a lot of delving in my own time when wrestling with the question of waivers. You've heard a lot of arguments based on familiarity and efficiency. You've posed questions based on what you consider solid ethical professional principles. Within the lengthy case statement we heard read out for over 10 minutes, there's a detail that's been overlooked in this analysis. This law firm already exists, has 3 full-time attorneys, 2 part-time attorneys. You did not hear in the case statement that absolutely none of these 3 full-time and 2 part-time can adequately professionally serve these clients. You did not hear that. That doesn't mean Mr. Gross can't do a good job, but can they do a good job? Further, some of the people supporting this waiver request are statewide agencies. If his skills are so paramount, could he help them with other jurisdictions because of his facility? And then within any agency, within any organization, you always want a backup, just in case somebody gets sick. If Mr. Gross is so skilled, if he's like the key man, what happens if he gets critically injured by a drunk driver, an errant tourist bus, racing teenagers? Does that really wipe out that law firm's skill and the ability of these firms to get adequate professional representation? Could he help his firm by doing in-service trainings from his skill to impart to them? At this point, I'm saying you don't have a solid case that nobody else can do it within that firm, that he can't help some of these providers now do better jobs outside. That's why to stop the idea of waivers being a common revolving door, you might consider that, and maybe also not rush to judgment tonight when you've got a lengthy, complicated agenda. Thank you.
Thank you.
Good evening, Commissioners and Director Pelham. My name is Hildegard Fullo. I've served on 2 civil grand juries and a friend of ethics. This commission has entered a new era of higher standards of performance. San Francisco is a city littered with conflicts of interest, repeat developers, and lobby groups that masquerade as nonprofits. Director Lee from the Mayor's Office on Housing used the word unique, not traditional, to describe San Francisco affordable housing contracts. However, civil grand jury work revealed it's not something unique, but instead filled with irregularities that beg investigation. Many building contracts in San Francisco are tainted, and that includes affordable housing contracts. Mr. Gross signed on with the city attorney's office, was advised of restrictions, and in my view, no exceptions for a waiver in this instance should be granted when possible conflict of interest hangs in the balance. Thank you.
Thank you.
David Pilpel, speaking as an individual. I listened carefully to the presentation and the discussion. I don't know Evan. I'm sure he's a nice guy. I assume he's a mensch. I'm sure he's done great work for the city. Nevertheless, the question before you is on the waiver request, and I think your questions suggested concern about both the instant requests and the precedent that it would set in other similar situations. I think that the city overall is not well served in general by granting waivers so someone who's familiar with the city side of a transaction or situation can work on the other side. I note in the list of agencies and projects, West Side Apartments, Midtown Apartments. That's, as I understand, a very complicated situation that may well result in litigation where the city and the nonprofit developers may not have the same interests. And in fact, in general, the city and nonprofit housing developers, although they have the same goal of developing housing, don't necessarily have the same interests in terms of how the transactions roll out. And so, in summary, I am not with granting the waiver. I think at a minimum you should ask more questions and continue this. But if the votes are there, I think you should outright deny it tonight. I think Leanne and the staff got it right, and I don't think the city is well served here. Just a couple other things I wanted to mention. When the Tom Long matter came before the commission, I believe I was at that meeting, and Tom Long is working for TURN, largely representing public ratepayer interests at the state PUC. I'm not aware that the city does development deals with TURN, so it's a very different situation. And I would also point out that there was another deputy city attorney, Celia Lee, who actually advised the Sunshine Ordinance Task Force, who left the office, I believe, just over a year ago to work for Goldfarb and Littman, which I believe also does work in this area of affordable housing, redevelopment successor agencies, that sort of thing. Again, a very highly specialized area. I don't believe she made any request for a waiver, did not come before this commission, and found other ways to be gainfully employed as an attorney, formerly having worked for the city attorney's office in this or a related field, and didn't need a waiver. So I think if Evan is as talented as we hear, and I suspect he is, that he could work on these projects in other jurisdictions or do other similar work, and that there's no public need for granting these waivers. Thank you.
Good evening, Commissioners. Mark Solomon, and I haven't said this very often, but I agree with the staff report, and I think you should follow it. It's nice to say that. I've got experience working in this area of policy advocacy and policy development. I worked with Director Lee about 15 years ago on the San Francisco Community Land Trust Task Force, which was another method of affordable housing where the city purchased rent-controlled buildings at risk of eviction for conversion into permanently affordable housing. But the policy choice has been made here to go for this Rube Goldberg machine of assembling huge amounts of funding that require very specialized skill sets in order to build new construction affordable housing. And that's not the most efficient way, in my view, to actually take public dollars and transform them into the product we want. So what the deal is, we want to get affordable housing. We've got a bunch of folks that make a certain kind of affordable housing widget that are very close in with the Mayor's Office of Housing. And they've decided to work together politically, outside of government, and inside government to go ahead and ensure that public dollars are viewed as their private property for the construction of the widget they produce, when it may or may not be the best kind of affordable housing that we need to devote scarce public resources to. As someone who's been involved in this for a long time, I have never heard of a public meeting where the Mayor's Office of Housing talks about a competitive process to allocate affordable housing dollars to developers. It may happen somewhere, but it doesn't happen in public. The reason why it's in the mayor's office and not under a commissioned department is to keep that basically in the dark. So you get these affordable housing people that make it their life's work to do this work, and it's ostensibly desirable work, but the outcomes never seem to quite get there. It's like that guy at the party who tries to play the guitar and gets that second note out and says, wait. No. We're sitting here 15, 20 years later seeing the production of affordable housing in no way scaling to meet the crisis we face. So what we have here is folks that are getting paid to do this work. They're plodding along slowly, and the displacement pressures are increasing so rapidly that they're really not up to the task to do it. So what we need to do is have this commission stand for what the staff has said and really take a stand on ethics. The previous waivers should not serve as precedent, and this commission should repudiate those bad acts in the past. And it's time to set a new course, a new day, and to let people know that just because you say you're doing God's work, this commission is going to go ahead and do the investigation, do the analysis, and stand here and represent the interests, like Commissioner Keene said, of the clients, we the taxpayers, the citizens, the residents, the voters of San Francisco, as you go ahead and represent us for this. I think it's time to go ahead and blow the lid off of what we have here as a very insular, closed community that does both policy advocacy and service provision / construction. And that's where the ethical knot is, the tight relations with government, advocacy, and then they advocate for the money they get. And that has to be just knocked out right now. You do advocacy or you do service provision or development, not both. And if it's too complicated, then you're doing it wrong. Thank you.
Thank you.
Hi, I'm Larry Bush. I'm just speaking for myself. I spent 15 years at the Department of Housing and Urban Development working on affordable housing issues, including in San Francisco. I have a great deal of respect for Olson Lee and have worked with him in that capacity and prior to that in the city government. And I've worked and have a lot of respect for people like Mercy Housing and TNDC. I think they do great work. The reality is that San Francisco is different than other communities. Here it takes about 20 to 30 organizations to fund a reasonable affordable housing development. In some other places it can only take 3 or 4 if you're in Nebraska or someplace. But here you have a problem with site acquisition, then you have problems with the cost of housing production. In many cases the site that's been chosen has got remedial needs that have to be taken care of, and that's a whole other can of worms. But in the meantime, while all of this is going on, there's a great deal in flux about the funding sources. So you saw that Governor Brown eliminated the redevelopment agency as a funding source for affordable housing. At the federal level, the Republican Congress eliminated fundings for senior and disabled housing, the 202 and 811 programs. And so what you have is, in the middle of all this, trying to reinvent who your funders are going to be. So it's a constant juggling act to come up with something that's going to pay off in the end. There's obviously going to be conflicts because some of the people who sign on as funders will drop out for one reason or another, and sometimes they'll drop out because they don't meet the standards one way or another that the city has. So while we all think of ourselves as partners together, and HUD certainly felt that way, we also recognize that there is differences in our responsibilities and differences in our oversight, and that they should not wash over into each other. I cannot imagine a situation where a HUD attorney for affordable housing would then take on a job like this immediately. They do take on other jobs, obviously. After all, HUD is being defunded for all proper purposes. But they do not go to the other side of the table as fast as this. Thank you.
Thank you. I would propose that we deal with these separately. One, the request for the waiver of Section 3.234A1, which is the permanent disqualification. And I would ask if I hear a motion concerning whether or not we should grant a waiver of that section.
Commissioner, I will say that I am persuaded that we should grant the waiver with respect to 3.234A1. It is a high standard. The potential for undue influence or unfair advantage is something to be taken seriously. But this does sound like a unique situation to me. And hearing so many from the MOHCD come and testify about why specifically it's so important for Mr. Gross to participate is compelling. The fact that the city attorney has given the waiver as long as it's not litigation, I also find compelling. And it's not only is there not, it doesn't appear to me specific potential for undue influence or unfair advantage. There appears to be a specific and significant advantage to the city, which I think is also compelling, especially in light of our housing crisis. I do likely have a different view with respect to the 1 year ban, but on the permanent ban, I do think we should grant the waiver.
Any second?
Second.
Discussion?
Yes. Thank you, Mr. Chair. This is very difficult for me because I feel tremendous affinity for Mr. Gross in regard to someone had mentioned that he is doing the Lord's work. And as someone who was been a lawyer for 50 years, and many years of that I was a public defender, and always told my students, go for something worthwhile that's helpful to people in general rather than to make money. I see Mr. Gross as an exemplary person in this situation, and I commend him for his career and for what he's been doing. And I can't see him taking advantage of anything or doing anything untoward. But even with that, I can't vote for granting the waiver because there is some substantive meaning to the fact that where you have two sides to things, and there are two sides, as we've seen tonight, and you have representation for each of those sides, that under the rules of professional conduct and under the standards for ethical representation, there shouldn't be a crossover. And in this situation, what we're doing, even though we'd be doing it just for the 1 year period, there is indeed the other factor that's been referred to, that in this city, the idea of the revolving door is something that has become almost pestilential in terms of doing business with the city and aspects of things which have arisen to the standpoint of corruption. That's not what's happening here. That's not what would happen here. But it is something that's real, and we see it just in the headlines of things that have been happening quite recently. The conflict of interest that's involved, the fact that Mr. Gross did indeed join the city attorney's office knowing that this was the rules of the game. Didn't have to take that job. He did, and I commend him for taking that job. And the fact that he now wants to move on, that's fine. But that was the rules of the game. Those are the rules of the game. And they're important rules. And I think we should stick to them. And even when we're looking at something and saying, well, this is really on the side of the angels, we should keep consistent on it. So on that, having said that, I'm going to vote against the waiver.
Any other commissioner?
Yeah, I will say that in hearing from so many, it was almost like this is your life. He got to hear wonderful things about himself professionally. We don't get that all the time, so that's nice. This was an exercise in hearing that. Where I thought was a little light in the argument is I really wanted to hear, and Mr. Planhold headed into this a little bit, was I wanted to hear about I understood what value add he will bring to the community and particularly to the city and county of San Francisco, but I wanted to hear from his colleagues or the partners and the part-time folks who are at the law firm to tell us, convince us what unique skill and ability and expertise he's bringing, and how that will increase the capacity that ultimately will certainly facilitate the larger effort of affordable housing in San Francisco. Many things are in hindsight, but it would have been great to hear from his professional colleagues to tell us a little bit more about that. That said, I will vote for a waiver on the permanent restriction. I just would say for sure that if you move forward with this and have an understanding of the work that you're going to do, it's important to have the support of your colleagues that you will be working with on a daily basis and not necessarily your clients or your potential clients.
I would intend to support Commissioner Herr's motion as to the permanent, waiving the permanent ban. I think that provision was put into the statute to deal with the case where there was a direct, particularly litigation matter, where there'd be a direct conflict in the attorneys sort of switching sides, as we've talked about. So, but I don't think, based on what we've heard, that there's a justification for saying he's permanently banned from representing clients in this area.
Can I ask a point of clarification of the city attorney's office? So the waiver from the city attorney did restrict litigation, and my understanding is that that is imputed to the firm that Mr. Gross is now going to, so that the firm could not represent any of these nonprofits in litigation against the city, his current firm.
Nothing in the waiver that we granted Mr. Gross addresses the firm, nor is I think there any default imputation idea, as there are with other conflicts of interest, as I'm sure you're familiar. But I think it's if what I was hearing, if I'm accurate in what I was hearing, I don't believe they do any litigation at all.
Well, they don't now. So why don't we? I'd like to amend my motion that it only applies to non-litigation matters. So if Mr. Gross wants to turn into a litigator against the city for these clients in these matters, that the waiver would not apply to that.
Okay, so consistent with the city attorney's office's waiver.
Yes.
Okay.
Do somebody second that amendment?
I'll second it.
Thank you.
I think the only comment that I want to add, since I'm always surrounded by lawyers here, and I have a real problem sitting in judgment of someone's career and livelihood. You know, the idea that I could vote to permanently ban this individual from pursuing his professional goals just to me seems completely outrageous. There is a revolving door with regards to lobbyists and influence peddlers. I think we all recognize that. But I think there's something wrong with rules or laws that somehow are so broad that they apply to people who aren't going to be doing anything like that. This guy has said it. He's working with transactions. He's a numbers guy. He's a finance guy. He's working out the details of something that's already been decided. I'm not willing to do that. And I think that it's something that we need to look at, and perhaps at some point we need to review ethics rules and where within city government they do apply. Clearly, you know, the whole business of influence and unfair knowledge and being able to determine things that are in the have an influence on projects that are in the public interest. Of course, we need to look at that. But you know, I'm not willing to ruin somebody's total career. So I'm very much in favor of passing the lifelong waiver, because that seems wrong to me.
All right, I'll call the question. All in favor of granting a waiver as to Section 3.234, paren A, close paren, paren 1, close paren?
Aye.
Aye. Opposed?
No.
Record reflect that the waiver was granted as to that section 4-1. Turn now to the 1-year restriction, which is Section 3.234, paren A, close paren, paren 2, close paren. Do I hear a motion concerning whether or not the Commission will grant a waiver of that section?
I will move that we deny the waiver request with respect to the 1-year ban. As the staff and Chair Rennie have pointed out, perception does matter in these issues. I think that Mr. Gross can still do the work that is beneficial to the city without communicating with his former colleagues for 1 year. And on that basis, I think the potential there is not I'm not convinced that he's met the standard with respect to the 1-year ban and would and move that we deny it.
Second.
All right. Any discussion? All right, I'll call the question. All in favor of denying the waiver of Section 3.234, paren A, close paren, paren 2, close paren?
Aye.
Aye.
Aye. Opposed?
Opposed.
Right. The record should reflect that the motion was passed to not grant the waiver 4-1. And I will call a 10-minute recess to allow restroom break.
Thank you.
Discussion and possible action regarding draft regulations for implementation of Proposition C. And I want to compliment the staff and Ms. Pelham for what I think was a very good job of trying to respond to the interested persons' meetings and the comments that they've received. But do you want to just briefly give us a report on that item?
Yes, thank you, Chair Rennie. The document that we have in Agenda Item 4 presents a first take at trying to address the issues that have been raised with regard to implementing regulations for Prop C. We tried to identify, or we tried to stay within the Commission's directive to be looking at this as an opportunity to clarify language in the existing language of the ordinance, and we note where there are recommendations that would likely require legislative change. So the attachment that you have in this item presents regulations that we have attempted to craft for your consideration and discussion tonight, and additional input by the public about key terms that affect the interpretation of Prop C and help people understand how to comply with Prop C's requirements for the new expenditure lobbyists. I would think that the question here is balancing a number of things. Specifically, the charge for Prop C was to make the registration and disclosure requirements as similar as possible to the language that applies to lobbyists under the city's lobbying ordinance. And also, we were trying to respond to questions about what counts towards the threshold for becoming an expenditure lobbyist. We tried to define what kinds of activities might count towards that threshold and how they count, and then also tried to give some guidance about forms that would be used both for the registration that's required and for the regular disclosure, the monthly disclosure that's required under the language of the ordinance. I would say we've had some very constructive conversations both at our interested persons meetings. Friday, some of us on the staff also met with, additionally, with some representatives of the nonprofit community to walk through in detail how would these regs work. This was after our draft regs were completed and going into circulation, but we wanted to take the opportunity to try and get our, further thinking and flesh out ideas and try to understand concerns. So, based on all of the information that we have here and the information that we've received, this is our first take. Our hope is that we can actually come to an agreement as an organization to enact implementing regulations as soon as possible, but we want to make sure that you're comfortable with it and we've gotten it as right as we can for the moment. So we're hoping to get additional feedback on this language now that we have something specific. We have been continuing to urge folks to give us specific language in response to this. I don't believe we have received specific amending language on this front. We did receive some comments from the Friends of Ethics. I believe it was yesterday, and I think we have all of the comments we've received on the public counter for you. One of the things I do want to point out before we launch into receiving more public comment is that we've been grappling with this question of what counts, what kinds of activities count. The language of the ordinance as to expenditure lobbyists is actually pretty clear in a lot of regards in terms of what counts. One of the key issues that kept coming up was how does staff time count, and how does that affect counting towards a $2,500 per month qualification? And one of the things that we don't have in the regulations before you, but we wanted to sort of parenthetically note for conversation this evening, is another approach that as we looked further into the language today, we might see some alternatives for how you connect the activities that are undertaken with the $2,500 threshold. And I guess what I want to do is maybe leave that until we get to the specific point in the regulations. If you'd like to walk through them, or do you want to take public comment first, and we can raise the issue at the logical point that to provide maybe an alternative for some of the language that we have before you.
Well, before taking public comment, I do want to give the commissioners an opportunity to whatever questions or comments they have on the draft Prop C implementation regulations that are part of the package. So does anyone have any questions or comments or concerns? Commissioner Herr?
Thank you, Chair Rennie, and to the staff for their hard work on this. I have some question. I have a bunch of questions, and I think I'll just start looking at Attachment 2, the proposed language, and in particular 2.105-5A and B. And what I'm not understanding is how you determine that a person makes payments at the time an expenditure for a qualifying activity is incurred when that might not qualify as an expenditure that would have to be reported until up to 12 months later.
I think the example there was, say an organization makes a payment for a report, and at the time of the report, it's studying an issue, and they have a particular viewpoint, or they want to present information on that issue. And then, say, 1 month or 6 months later, that report is distributed to the public, or urging action on the recommendations that the report contains, urging others to communicate with the Board of Supervisors, and they use that report in that context. Mm-hmm. The question is whether that, when and whether that would, or whether and when that kind of expenditure would count. And so what we tried to do is to put in some sort of temporal connection to suggest that if within 12 months of developing that report and it was used as an attempt to get others to communicate, that cost should count towards the $2,500.
So when do they report it?
I think in this case they would report it at the time that the communication urging others to communicate happened. Because until a communication with others or urging others, you're soliciting others to communicate, to lobby an official happens, there really isn't one of the key elements of an expenditure lobbyist definition that's been reached.
That makes sense to me, but I'm not sure these implementing regulations say that.
Okay.
So a person makes payments at the time an expenditure for a qualifying activity is incurred. So I pay for the report on day one. I don't use it to publicly communicate until day 364. When do I report? Doesn't this suggest I report on day one when I incurred the expense, when
Yes.
I paid somebody?
In isolation, A does. Yes, I think we have some tweaking to do.
But I don't know. I'm not sure that's a matter of tweaking. I mean, that appears to be a fundamental disconnect. I mean, you'd have to say the opposite, basically, that it's a payment at the time the activity becomes a qualifying activity. It wouldn't be tied to when the expenditure is incurred, necessarily.
I think I understand your point. I'm struggling to come up with the language as I sit here.
Okay, well, maybe something to consider. And I mean, I do think we need to figure out how to make that work.
Well, isn't what you were seeking to do with this language was to respond to the concerns that were expressed by a number of the interested persons that if they prepared a report, but at the time they prepared it, it was not for the purpose of urging action by a public official or taking action on public matter. And then they said, well, and then maybe it gets used later. Is that does that bring them in as an expenditure lobbyist? And the question was, if it's more than 12 months, the presumption would be that it was not done for that report wasn't prepared for that purpose. Once the 12 months ran, if they then issued the report, it would not count as an expenditure because that was something they just had in there, had already spent, but it was not spent with that intention.
Yes, and although I think, Commissioner Herr, your question is slightly different.
Right, yeah, I agree with what you said,
yeah.
Commissioner Rennie. I get that, but the point is when you have to disclose it. And if you don't know, right, if at the time you do the report, you don't know whether you're going to use it to communicate, and you do 6 months later.
Then you would have to disclose it.
Right, but I think this suggests you disclose it at the time you incur the expense, which is when you pay for the report. And I think that's the problem.
Yeah, so, A and B are not working in sync with what we described. So I understand your point.
Okay, thank you. My other main point question had to do with this pro rata salary attribution. I mean, I'm very curious to hear what your view is on how we make that happen, because it sounds incredibly difficult to me.
This is under subsection D, 2.105-5D.
Yes.
Bless you.
This is an area that had a lot of question, as I mentioned, for organizations. If you have individuals who are essentially in-house, who are doing activities that could count towards a qualifying threshold, so developing public relations materials, doing outreach, doing reports, urging others to communicate. The first question was, should those completely be exempt because they're in-house activities and are not making a payment? This approach suggests that they should be treated the same, whether you're making a payment for in-house services or whether you're making a payment for an external consultant or organization to do that work. But the second question speaks to when you count towards the $2,500. This is what I was getting at a little bit earlier. does the counting towards $2,500 tie to a specific matter of legislative or administrative action, or is it $2,500 in activities spent towards any and all legislative and administrative matters? And our first take was that it appeared to read to us that it was any and all combined. So that if you're spending time on any and all matters to urge others to communicate, for example, with the Board of Supervisors, it didn't matter what matter they were. Once you did it at the level of $2,500, you met the threshold. When we were looking again today more closely at the language and also mirroring some of the approaches of, for example, the Los Angeles major filer requirement, we dug a bit deeper and we were trying to look at what do we mean in the definition of legislative administrative action when it speaks to any, the items that are subject, potentially influenced. It speaks to any matter, any resolution, but the emphasis is the word any. So when we looked at that, and we also looked at how the Los Angeles model is drafted and interpreted, and as we heard comments from nonprofits and others about how do you count towards the 2,500, we think there's some room to look at that to really crystallize the issue by saying that the $2,500 counts on a particular, on any resolution or any. So it speaks sort of a one-to-one relationship. I'm not sure if I'm being clear.
I think I understand what you're saying.
That rather than activities in their total reaching 2,500,
right.
that it sounds like the requirement may speak to you have to do $2,500 to urge others to communicate on any resolution or any approval. So it's a singular matter that has to trigger before you qualify as an expenditure lobbyist, which is different than what we're talking about early in this first draft.
And what were you thinking about how the pro rata amount would be determined?
And could you clarify what you mean by pro rata amount?
Sure. Well, I think what you're suggesting is I have a job at company A. A small part of my job is this expenditure lobbying. I do it for 10 different organizations. Am I supposed to track my time for each one?
Yes.
And then divide by my total hours that I spent that year or that month?
Well, it's a monthly test. So every month, I think this would assume that individuals are tracking the time that I'm spending on developing materials to urge others to communicate on a matter, on a particular matter, that I'm tracking that time by matter, so that if my time certainly reaches $2,500, then I have tripped the requirement.
I mean, this strikes me as an incredible burden on especially small nonprofits. I mean, my job, I track my time an eighth of an hour all day, every day. It's hard, and to have to report I don't do any of this expenditure lobbying, of course. I mean, it's different, but I mean, this is not easy. And for a nonprofit to do that, it seems like a recipe for disaster, in my view. Why not have it be outside expenditures?
Well, I think we posed that question, and it's an approach that the Commission could take. Our view was that when there are expenditures that are being done, regardless of how an organization chooses to do them, if they are drafted or developed with the purpose of urging others to communicate with an official to urge a certain outcome on legislative or administrative action, it doesn't really matter how they do it. It's the same kind of activity. And so as we were thinking about how the $2,500 is counting, that seemed to alleviate some of the burden for perhaps the smallest of organizations, because they may never get to that level on any matter or any particular resolution or any item.
Potentially, but if they do, wow, that's going to be a lot, and I think it's going to dissuade in-house people from doing any of the grassroots lobbying that they want to do. The other thing is, I mean, when we put this together, at least for me, my main concern were some of the examples that, frankly, I heard from Mr. Bush and others about. This company is paying people to show up at a meeting. They're hiring buses and feeding them, great meals. And really, they're not. The people coming to this meeting aren't really there because they care about the issue. They're there because Company A is basically incentivizing them to be there. And those are the types of things to me that are really of a big concern for the public. If you have an in-house person who's a public relations person, and I mean, how much are we really getting by knowing that? And how would they even divide it? I mean, they get paid X amount a year, and so they report. I mean, it just seems onerous and information that's not going to be particularly useful when it's an in-house person. But I understand. Thank you for explaining the point. My last question had to do with, and I just want to make sure I'm understanding it. In the memo, I'm sorry, it's on page 2 of attachment 2 under C at the top of the page. So I guess it's 2.105-6 C.
Okay.
Is it right that if an organization distributes a non-regularly scheduled newsletter to its members, that is excluded?
Under C, this is payments that an organization makes other than a regularly scheduled item.
Right.
To both members and its non-members.
Right. So if it's just to members.
If it's just to its members, then yes, that is excluded.
Okay. I found the language confusing. I don't know, maybe if there's something we can do to make it clear that it's that a communication.
I think that's under B. Does B address the question?
Well, but B, there's more than one distinction. In B, you've got regularly scheduled, regularly produced, regularly distributed. So it's I mean, really, the point is not its members; it's non-members. If there's an irregular newsletter to non-members, whether or not you're sending it to members, that's the point you're trying to get at in C, I think.
Understood.
Thank you.
Well, are you saying that if there's a newsletter sent to members, but not in the regular course, in other words, it's a special one, that would not be covered under expenditure lobbyists unless it also included distribution to outside people?
Let me just read this for a moment. I can help you with what I think we tried to do with it.
Yeah. Commissioner Rennie, I think that is true because the provision itself excludes communications to members. Yeah. The actual ordinance.
Well,
whether regularly scheduled
all right.
or not.
In other words,
yes, member communications are exempt under the ordinance itself.
Because your B, it sounds like B is talking about
B is, we were trying to get at when there is a combination of members reached and then some quantity of non-members. Does that change the nature of it, and if so, how? And
okay. Any other questions?
Yeah, all I will say is it's all incredibly way too detailed and hard to track. I'm just going to call it for what it is. We'll dance on the head of a pin and we'll wordsmith the absolute mess out of it, and to the implementation of it, the tracking of it, the monitoring of it, specifically on the nonprofits. I'm going to tell you it's a nightmare, and I get in principle why we are doing this, but it feels like we are shooting every chicken in the coop in order to get one good chicken to eat. And it just feels awful, because I know that out of the totality of the nonprofit sector, when you map them on the size of the organization and the nature of the service that they're providing, and the people who we ultimately seek to target and hold under regulation, who are having these AstroTurf activities, it just feels so incredibly, I don't know, it feels like a broad shot. And it feels like a broad shot that I'm just going to go on record and say that it will have unintended consequences. It just will. And unintended consequences meaning a lot of nonprofits are going to find themselves in violation, don't even know they're going to be in violation, don't have the internal infrastructure of a sophisticated timesheet tracking system in order to even do that, even to do this. And the salary piece, which one, which is a
D?
2.105-5D. With internal salary and tracking, it's unfortunate. I will tell you that is one unfortunate piece, because that is going to be very, very hard in order for these nonprofits to track. The other piece that I would say is, I know we're talking about these things, but I don't know that we ever came to, it seems to me that out of hand we just went and decided that $2,500 is the number, and I know that we would have to go legislatively as an amendment in order to raise it to $5,000. But I feel it's worth contemplating or deliberating if some of this could be solved, this broad shot that we're doing, by just raising the number in some kind of way. And I understand that it takes another administrative action in order to do that, but for such a it's a lot of work for such a low number. It's just, it seems like a lot of administrative work for such a low threshold to meet. So the internal piece I struggle with, and the threshold I struggle with. And I understand that the threshold has to be solved in a different way, but the unintended consequences are clear. They're not going to be in the long term. These will be short-term consequences that start on the clock the moment we put these regulations in effect. Because those folks won't even have time to figure out what a sophisticated tracking system looks like in order to do that. Certainly on the salary piece, on the internal expenditure, on those salaries.
Well, what does this, the salary thing is also in the state, some of the state regulations, isn't it, to apply?
Well, I think the state has, for its lobbyist registration purposes, has a exempt or some sort of provision for a certain percentage of time that is sort of a pass before they start qualifying. But that, again, we didn't look to that here because that's not what our contact lobbying requirements include. And again, we were looking to see if we're trying to be as comparable as possible while still having reasonable regulations. You know, we didn't think that having a 10% test was going to be any easier for folks to have to track.
Would it be inconsistent with Prop C to eliminate the charge of internal salaries as being a expenditure?
I don't know. Do you want to?
Yeah, so I think on that issue, the Commission does have flexibility to focus on this internal versus external payment issue that I think several of the commissioners are kind of circling back to. It sounds like at least Commissioner Herr was focused more on the external payments, and I think that's reasonable. It's not something precisely answered by the proposition itself.
So that we could, to meet what Commissioner Andrews is concerned about internally in the problem of keeping time set records and all that, if we limited expenditure lobbyists to actual payment out as opposed to what salaries are being paid.
Right. I think that's something we could do via regulation.
Okay. I will call for public comment.
Good evening, Commissioners. Debbie Lerman from the San Francisco Human Services Network. I am here to say, sadly, that we have very deep concerns about the vast majority of these draft regulations, particularly in 7 areas. I went to one and a little bit of another interested persons meeting. There were about 40 people total that came, and other than the nonprofit fee exemption and the fiscal sponsor provision, most of the regulations are contrary to what the vast majority of the public expressed in those meetings. These regulations will exacerbate the impacts that we have been so concerned about on community engagement and public policy, particularly at a low $2,500 threshold. And we feel that where the ordinance was unclear, staff chose to interpret the regulations as strictly as possible. For example, in the non-member communications area, we believe that if a communication is going to our members and includes some non-members in the communication, that should be exempt because we would be doing it anyway, and there is virtually little or no additional expense for the non-member piece, and it's too hard and burdensome to try to track that. researches, this 12-month rule is very confusing and could be very arbitrary and unfair. If we do a study and it's totally not for the purposes of lobbying, and we're going to do it no matter what, and then months down the road, part or all or even a little piece of that research becomes relevant, all of a sudden you can find yourself forced to register because of a study that you never in your wildest dreams thought would be a lobbying piece. We have concerns about the definition of members, the lack of a clear definition of administrative action. Other concerns, I'm running out of time. What I most want to say is we hope you will not approve these tonight. These regulations came out on Friday. Most of our colleagues haven't even had a chance to look at them yet. We would like to have the opportunity to do written comment. We would like to see another interested persons meeting where we finally have something to react to and can have a broader conversation on how these will affect us. And we would like to see a revised version come back to this commission in February. Thank you. Oh, I still have 30 seconds. I'm not going to leave yet. Lobbying needs to be regulated for purposes of transparency, but it needs to be done with a scalpel so that we do not infringe on the right to express our First Amendment rights to petition our government. Thanks.
Good evening, Commissioners. My name is Jonathan Minster. I'm an attorney with the Sutton Law Firm. One narrow issue that I believe should be looked at by regulation, but also speaks more largely to the question you've been asking about internal versus external staff time, is the question about what if an employee, either of a nonprofit or of a corporation, whoever it may be, goes on company time to testify before a commission such as yourselves. It's an interesting issue because while under the contact lobbyist rule, this person will not have to register as a lobbyist because excuse me one second, because public testimony before a commission is exempt. Why would they have to therefore register or act as a expenditure lobbyist in situations where they have spending staff time to testify before you as well? So that's one very narrow issue, but kind of speaks to the larger issue about, what really was the intent of the law? What is the purpose? Are we really trying to track this internal versus external time? And I hope that's something you guys will consider, because I don't believe it was the intent of the law to make them register to make the payment constitute an expenditure lobbyist expense, but not a contact lobbyist reportable in that way. Thank you very much.
Thank you.
Good evening, Commissioners. Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. I wanted to talk about a few of the provisions with regards to the proposed regulations. And regarding the expenditure lobbyist definition, subsection A provides that a person makes payments for purposes of the $2,500 threshold at the time an expenditure for a qualifying activity is incurred. First, I think it's important that the term qualifying activity be clearly defined. And second, the time a person makes payments should not be when an expenditure for a qualifying activity is incurred, but rather at the time a communication is sent, soliciting, requesting, or urging other persons to lobby city officers. A person should not be deemed to make payments for a qualifying activity if a communication is never sent. Subsection B imposes a presumption that the payment for activities will count towards the $2,500 threshold if the payment was incurred within 12 months of the communication urging others to lobby. And I believe a more reasonable time period for the presumption would be 6 months rather than the 12. D counts the internal staff time towards the $2,500 threshold. And when Proposition C was being debated, there were no complaints regarding internal cost of various organizations. The complaints focused on the external cost of organizations for ads and payments for transporting members of the public to City Hall to lobby. So imposing a requirement to determine staff's prorated salary, potentially dating back 12 months, will create an unnecessary reporting burden on those attempting to comply with the law. regarding member communications, the definition of the term member includes, among other things, any person who takes affirmative steps to receive an organization's communications. That's an extremely broad definition and would exempt every organization which simply provides an opt-in mechanism to persons who wish to receive the organization's communications. Subsection B exempts payments for regularly scheduled, regularly produced, and regularly distributed newsletters from counting towards that $2,500 threshold. It's uncertain whether or not that exemption applies when the newsletter is distributed to anyone or just to an organization's members. That should be clarified. And I think based on the plain language of Prop C, this regulation should also clarify that payments made for the production and distribution of any communication, regardless of content, to an organization's members will not count towards the $2,500 threshold. And finally, with regards to the registration and reporting proposed regulation, subdivision B provides that reportable payments made during a reporting period means expenditures that are incurred during the reporting period. As I noted earlier, those payments should not count towards that $2,500 threshold when incurred, but rather when the communication has been sent. Thank you.
Good evening. My name is Sarah Matlin, and I'm the bilingual counsel with Alliance for Justice's Boulder Advocacy Program. Thank you for the opportunity to speak with you. Through our nationwide Boulder Advocacy Program, I teach and offer technical assistance to nonprofit organizations about tax, lobbying, and election laws, so nonprofit advocates can confidently advocate for community change. Alliance for Justice has many concerns about Prop C and its implementation regulations, so we are grateful for the understanding that the commissioners who have so far spoken have demonstrated about the complexity of compliance. I would like to raise two concerns about Prop C implementation regulations. The first is procedural. I'm very happy to hear that it sounds like there is not an intention to try to pass or not pass these regulations tonight, because we have a serious concern about a possible violation of due process. Because these regulations were published on Friday, January 22nd, and a business day later, the Commission, we thought, might be considering a vote on these proposed regulations. And that would not allow the community to have a free and fair discussion about the proposed regulations, to research them, to explore unintended and intended consequences of each proposed regulation. And we ask you to table any vote on the proposed regulations until more than just a handful of people have had a chance to peek at the proposed regulations. The second concern is substantive. It's reasonable for lobbying disclosure ordinances to cover lobbying about new legislation or even new administrative policies or procedures. However, currently, the proposed regulations do not distinguish between new legislation, policies, or procedures on one hand and enforcement or community education about existing laws, policies, or procedures. As far as we can tell, unfortunately, the law might cover referring a victim of employment discrimination to the San Francisco Human Rights Commission to file a claim against her private employer. It could also potentially cover a motion to set aside denial of a restraining order in a domestic violence case or an appeal of an eviction order before a judge elected to San Francisco Superior Court. This can't be what the voters intended when they approved Prop C, and I don't think it was what the Ethics Commission intended when it drafted Prop C. I'm an attorney. I've worked in nonprofit organizations that assist clients with discrimination cases, restraining order cases, and eviction cases. And now I'm a specialist in this field of advocacy law for nonprofits. But I can't figure out if these types of interactions with city officials would count as lobbying under the current ordinance and proposed regulations. We need clear regulations to exclude enforcement of existing legislation or regulation. The Ethics Commission should adopt the California lobbying disclosure law's definition of a legislative or administrative action, and the definition of expenditure lobbying should not include assisting specific individuals with specific cases. Rather, it should talk about new laws, new regulations, new policies, and not specific cases, enforcement, and informing the community of their rights. I would be happy to answer any questions for the Commission.
Good evening. My name is Kevin Bogus. I'm the Director of Policy at Coleman Advocates for Children and Youth here in San Francisco. We've been around for 40 years. We work with parents and students around issues affecting them in schools. We primarily work with families in Districts 10 and 11, the south part of the city. And what we essentially do is we help students and parents lead campaigns to transform their schools and address some of the issues that have historically plagued them in education. And Prop C essentially turns our members into lobbyists. Expenditure lobbyists for trying to defend their rights to get a high-quality education. So I'm here today to ask you to be champions for the parents and students and the families we work with. San Francisco has one of the highest performing urban school districts, but African-American Latino students are left out of that. We have one of the biggest gaps between white and African-American student success. And I'm worried that this legislation could potentially harm our ability to work with students and parents to actually put pressure on the school district to address these wrongs and to fix these issues. And so I asked for the commission to support us and the students and the parents that we work with to ensure that their voice can be heard and that these kind of issues don't get bogged down in the bureaucracy that sometimes comes with having to file additional reports that is going to come to us through this expenditure lobbyist, where our members are really just trying to advocate for their rights to high quality education and to improve their lives. And I do just want to say I do appreciate the efforts that the commission and the staff have taken since the legislation is passed to really have community engagement, to engage in these conversations. I've taken part in the community interest meetings with a lot of other community folks, and even though we haven't necessarily gotten all the things that we wanted thus far, we do appreciate the time and the energy that you've taken to listen to us. And we hope that you take our concerns in consideration and take action to make sure that students, parents, and other people who don't typically have access to people in power still can have their voices heard. Thank you.
David Pilpel, speaking as an individual. I think this is a difficult process to interpret and provide guidance and regs on a law that this commission moved to the ballot very quickly, I think perhaps without considering fully all of these consequences. I think staff has done a good job under the circumstances. I think there is more work needed. I'll leave you a copy of some markups that I made to the proposed regs. I think Anita, and if I'm getting it right, Ms. Matlin, got it right in their comments, and the other speakers as well, that there's more work that needs to be done and that there are some sections here that don't quite work, particularly Anita's comment about when an expenditure is incurred and the timing of incurring an expenditure and reporting it. I think there also needs to be a section added in 2.110-10, either B or a new D, about the timing of reporting requirements. I think 2.105 really only goes to the definition, so the timing of when one would report, I think, is appropriate in 2.110. I think the overall intent here was to capture more of the activity that's not currently being reported, and the way it's written really affects everybody at a relatively low level. So if someone, my understanding is if someone is getting $25,000 working at a nonprofit, if they're spending 10% of their time creating communications to urge others to communicate with an officer of the city and county to influence local legislative or administrative action, that $2,500, 10% of their $25,000 salary, qualifies that activity as a reportable activity as an expenditure lobbyist. If I'm not understanding that correctly, I'd like to have that clarified. Excuse me?
It's monthly, David, not annual.
I'm sorry, monthly.
So if they're getting $25,000 a month, then yes, it would count.
Okay, thank you. Thank you to Larry. On the question that I believe Ms. Matlin raised, I don't think referring someone to an appropriate agency to file a claim or to pursue some of the activities that she discussed is the type of urging someone to communicate with an officer of the city, and those officers are pretty narrowly defined, for purpose of influencing local administrative or legislative action. So if someone wants to organize a campaign to influence your decisions or the decisions of the task force that I sit on or the committee that Larry sits on, then those would be administrative or legislative actions, and we would be the officers. But it's not everyone, and it's not referrals in all cases. Thank you.
Thank you.
Sorry. Here, Leanne. Thanks.
Members of the Commission, Gen Fujioka. I work for the Chinatown Community Development Center, and part of my job is to make sure our organization complies with law. And I've been looking at the rules, and I've been trying to figure out how to comply because I don't think these rules match. I mean, these rules. There are clear examples of where these rules should apply. If we went out and we hired a consultant to do a poll on legislation that's before the board, clearly that's an expenditure, and it would appear that it would fall under the law. We should report that. We should indicate that and do a filing. Similarly, if there's pending legislation and we commission a report, research or whatever on the topic, and somehow the report ends up before you or some other commission, we should report that. We get that. Those are clear cases. The problem for us on what we do on a day-to-day basis is we're eyes and ears in the community. We are doing research all the time where we produce reports. We do earlier last year we produced as far as I know, as the only report calculating what the rents are, market rents are for residential hotels in Chinatown. We did a collaborative project with organizations throughout the city evaluating the living conditions for families who are living in residential hotels. Those were pieces of research that we did. We have no idea at the time that these are going to they may turn into legislation, they may not. But during the time we do this research, we're not tracking everybody's time. We work. It's not with the intention that we are doing advocacy in the sense of some piece of legislation or administrative advocacy. So it's the way that the rules are set right now. I look at this. I'm supposed to predict or anticipate what pieces of work we're doing when we're talking to clients, when we're doing surveys in the neighborhood, whether this might be legislative activity or administrative activity 12 months away, and we don't know. That's not the purpose for most of what we do. Again, there are clear examples which may be expenditure lobbying, but the day in, day out operations of our organization, we couldn't. If the legislation, sometimes we've done pieces of research that have then become the catalyst for an agency, the rent board or the planning commission, to take action. And then we have the report. They're looking at our report. It has no reference to legislation because legislation didn't exist at the time. So what we should do, it seems to us that the idea of a look back is very problematic for organizations that are not anticipating that research or work we're doing in the field is going to subsequently become the topic of administrative or legislative advocacy. We did propose some specific language along with HSN and the Coalition of Community Housing Organizations. And that, with respects to research, it seems to us if the idea of this legislation is to have full disclosure, then if our names are on a piece of research and we put our names on it, we're the true source of the funding, and we indicate on our report, we funded this report, and there's no specific reference to legislation, then we're not sure why that research, even if it's used 6 months from now or 7 months from now legislation, what public service, what additional requirements there should be for us to go back and figure out how much our various staff people's time went into publishing the report. The purpose, if the purpose of this legislation is to ensure that the public knows where information is coming from and who's paying for it, let's make sure our reports disclose that, and hopefully that there's no other additional requirement that we need to go back and then calculate cost. Thank you.
Thank you.
Hello, Commissioners. Larry Bush for Friends of Ethics. I appreciate the work that the Commission has put into this and the staff, as well as the many excellent comments that have come from members of the public testifying for you. There are a couple of points. I've already sent a memo. I'm not going to repeat everything that's in the memo to you folks. But in terms of the comments that I've heard tonight, I just want to say a few things. In terms of keeping track of internal staff spending money, take a look at Comcast. Comcast reached out to all the nonprofits that have funds and asked them to show up and lobby on behalf of Comcast's dispute over internet access. That was a direct example, it's been in the newspapers, of expenditure lobbying. And you know that Comcast was paying someone in their staff a lot of money to put all of that together. In terms of advocating on policies, issues, as was suggested about the school things, it depends on the case. Let's say you have a policy at the police department on tasers. It already exists, but then there's going to be a lobbying effort to change that policy or to not change it, depending upon the case as it goes. Mostly when you guys put together regulations, there's also sort of a Q&A where people can ask questions and they get put into the record about, well, if I do this, does that count? Or if I don't do this, am I doing something wrong? And some of the questions that have been raised tonight would fall into that category. I just want to make one other point, and that is the size of nonprofits is relevant to some extent. But if you take a look at on the ethics page for major developers, where they are required since last year to disclose if they're paying $5,000 or more to a nonprofit for the specific purpose of going before a city agency and advocating for the developer's projects, they have to list who are the groups and how much money they gave them. So I looked at that list, and you've got groups like Spur, who has a $20 million budget, but getting $25,000 from a major developer to push for their project. You have many nonprofits, not many, but a dozen nonprofits, some of whom are members of the associations that have spoken here today. But those are only disclosures on development projects. They're not disclosures on contracts. They're not disclosures on policies that may take place, like on the soda ban that Coca-Cola was involved in. So the Proposition C expands the kind of disclosure that you see in part in the major developers. I would recommend that you take a close look at the points we made and include those that you find valuable as amendments in a reworking. Thank you.
I'm Bob Planthold. I want to speak on 3 points and make a couple of administrative process suggestions. The suggested definition of member is way too broad. Seeking information. If I contact a senior housing provider and say, I want to get on your list of when there's openings, I'm seeking information. I'm not a member. There's no business contract between them and me. I think you can't do that. On whether or not to exclude internal expenses, here again, I think you should not exempt internal expenses. You may need to better define it. And here's an example. $2,500 is your current threshold now. So if a person working for an agency is tasked in August to develop a report that'll be used by a supervisor who's going to introduce something in September for a hearing in October, well, you're paid in August for that report, and there's a deadline that it's going to be used in October. Or for a ballot measure, and you're developing a report that's going to be handed out to the voters the beginning of November. Well, that's several months away, but it's still an expenditure in August because it pays the salary. I think you should not exempt that. So then, if we go to the fact that you're seeing a lot of complications, well, I think you do have the possibility, or you ought to try for adopting interim regs, and maybe make them skeletal, and make it applicable for 6 months while you work out something in detail. Potentially that gives you some leeway. You might even want to say during that interim time you may not levy fines until things are worked out, without a guarantee, but people shouldn't feel harassed when they're not clear and there's an educational time that they need to deal with on this. I also want to support the idea that you should not exempt some groups, as Larry mentioned, who are getting $5,000 or more from a developer, because some of these groups get multiple $5,000s for multiple developments. They can certainly afford to pay that $500 fee when they're getting $5,000, $10,000 or more. I think the exemption blanket, again, is too broad. It needs to be studied carefully. And I guess I'll also point out, those 72 hours may seem sparse time. That's what complies with Sunshine Ordinance. Again, that doesn't give people a lot of time, but technically it complies, and that may be another reason why you should adopt skeletal interim regs so that more people have time to get acquainted, to have workshop sessions, interpersonal lessons, staff do more research on what FPPC or LA or other jurisdictions have, and then come back in a few months with a better framework. Thank you.
Thank you.
Sorry. Bruce Wolf. I want to apologize to Ms. Pelham because she probably hasn't been here since the beginning, thus may not be aware of all the details and dynamics that brought Prop C forward and what we've been dealing with here. There is California precedent to delay the implementation of a voter-approved law. For instance, with the same-day voter registration law in 2014, it's set to go into effect this year because there were various aspects of it that they could not put together in time to implement it. So I would like for you to take that under consideration and research that. Staff's recommendations are concerning. First, it's not the public's responsibility to provide actual language in legislative form. I'm not suggesting that there is specific position or an agenda here, but more so we felt the interested persons meeting was an opportunity to brainstorm concerns in a roundtable fashion to come to some agreements that are amicable to all parties so that your process would move forward smoothly and expeditiously in implementing Prop C. These recommendations that were provided by staff introduce provisions that we're just learning about and were not mentioned in any of the IP meetings. Unfortunately, staff's response to our testimonies at the last hearing here and the following IP meeting did not take any of our concerns really kind of seriously. Instead, the way I read it, staff's recommendation is that Prop C should move forward pretty much unchanged and unfettered. This is unacceptable and frankly unfair in that it appears shifting the responsibility elsewhere to provide some balance for all stakeholders, but not in the interest of all people involved or all organizations. I request that a full open forum with all of you, commissioners, present be held in a collaborative format to assure and achieve some uniformity and consistency. Now, I continue to stand on point that Prop C is targeted for front groups with regards to nonprofits that are primarily funded by private corporations and shield those third parties from liability. We've heard from some of you the interest of this commission to wrangle in bad actors. I assure you we are not them. The nonprofit groups you are hearing from today provide direct service and or advocacy congruent to its mission and not front groups or astroturf on behalf of third parties with potentially nefarious motives or needs to shield themselves from liabilities and public opinion. I'm not going to be able to get through all this, but there was a great article in Green Car Reports by Dan Basher that points out that the Western States Petroleum Association, in its efforts to kind of defunct AB 32, which is a major climate change bill, created 16 front groups that have really no members or no interest unto themselves. They only had interest in the Western States Petroleum Association's interest, and that's it. And that's the definition that you should go by. Thank you.
Thank you.
Me.
Commissioners Ray Hartz, Director, San Francisco Open Government, and I'm going to do something, you hold on to your arms of your chair. I'm going to congratulate both the Commission and the staff on the fact that this law was passed in November, and here is it in January, and we have a solid proposal right in front of us to look at. And I agree with a lot of the people tonight. Approving it tonight would not be appropriate because there should be a lot more discussion and public input for two reasons. One, so that all those that are subject to the law have a very clear understanding, or at least a fairly good understanding of what they're expected to do, and some suggestions from perhaps staff on how they might effectuate carry out those responsibilities. The question raised about when you have to report a report. Suppose I'd like to use the opposite opinion. Suppose I decide and commission a report, cost me $7,500, and my full intention at the time I commission it is to use it for the purpose of influencing legislation. And then I get the report and I realize that 60% of it is not going to be in favor of what I want to do, and I just chuck it off to the side. Now, if I'm required to report it when I do it, now what do? Do I go back and say, well, I reported this, and actually it's never going to be used for the intention, so it really doesn't comply anymore. Can I withdraw my filing? Obviously, you can see that would be a nightmare. The questions here have to be ones where not only are the public and the people who are subject to this law need to have clarification, you need to have clarification. I think we saw it in the last issue where you were kind of discussing, what a lifelong waiver or year waiver or whatever. You have to be clear on what the law is so that when you do come to enforce it, you can do that with some degree of confidence in your decision. The last thing I'd like to say is you're not in this all alone. One of the things that I've advocated is the access to public records, and I've repeatedly at boards and commissions suggested if every single city agency took every document which was not subject to restriction and put it on their website, they could cut down all their concerns about having to answer public records requests. I could go to the website. If I saw the document, I could print a copy or a page or whatever, and there would be no requirement, no expenditure of the city at all. Michael Petrellis has been fighting to get the schedules, meeting schedules of various elected officials, and they resisted it immediately. If they were required to tell everybody in the public who they met with, some of us in the public, would see those names, look at your list of the things, and help you with your job.
Your time is up. Thank you.
Good evening, Commissioners. Peter Cohen, Counsel of Community Housing Organizations. I'll repeat what you've heard from several folks tonight, which is we ask that you not adopt anything right now. This is obviously a piece that needs a lot more work and discussion, and that you direct staff to hold at least one more interested persons meeting so we can actually discuss the draft that's in front of us and hopefully revise it and see some of our concerns incorporated into a revision. So that's where I'd like to end, but let me echo what you've also heard, which is from the nonprofit community in particular. We have a lot of concerns with this first draft. It is, perhaps without intention, but it is the most sweeping interpretation of Prop C, which has a number of significant impacts, unintended consequences or not, and unfortunately doesn't reflect on what we think has been a fairly good dialogue for the last 6 weeks with you all at the interested persons meetings. A lot of these issues have come up, and it seems to take, again, a very conservative, sweeping interpretation and doesn't reflect that dialogue nor the public debate that happened during the ballot measure itself. I want to focus on what you've already talked about yourselves, but is one of the most fundamental red flags, which is that staff time is counted as expenditure lobbying. I mean, this is the day-to-day chock-a-block work that a lot of community organizations do across all staff and all functions of an organization, and I can't even imagine how that would work at a practical level, let alone asking the question, is that the intent of what the voters expected this was about? I think you've heard it from many others, and it was very heartening, frankly, to hear your counsel tell you that it's your prerogative to decide whether this really is, and the voter intent really was, about payments to others to do that kind of work in influencing legislative activity, not about the organization's own internal work and the staff and the work that they do on a day-to-day basis. I think if that one bright line can be part of what you direct in these regulations, that will be a significant relief and will speak to the kind of world that we operate in. It's not the only concern. The other I'd like to point to, and I actually want to credit staff for bringing this up tonight, is a revised proposal to you, which is counting expenditure should be around specific legislative activities, not just the aggregate of nickels and dimes of this and that and everything else. Does it reach 2,500? But clearly this is about spending large amounts of money on specific legislative activity, and I think if that interpretation is what you embrace, along with excluding internal and really focusing on external payments, it really starts to get at what I think is the heart and the intent of Prop C. So we want to work with you going forward and come back in February. Thank you.
All right. Let me say that it was never contemplated when this item was put on the agenda that tonight we would adopt the regulations. It was the staff's understanding they were going to do a first draft, which would give everybody a chance to express their concerns or their agreement, and to then go back, and I anticipate that on the February 22nd agenda you will see essentially the same agenda item, and at that time we may take action. But in the meantime, and I will leave this up to the executive director as to whether or not she wants to schedule additional interested persons meeting between now and the 22nd. Certainly, if you think it would be helpful, I would encourage it. But insofar as I think you've gotten some comments tonight from commissioners, I don't know if any of the commissioners want additional comments to the staff for purposes of these regulations, but I think it was, and I think even insofar as implementation date, which I think is the 1st of March, I think it was envisioned that whatever regulations we have will be interim, with an understanding that the commission can amend them or modify them or do whatever they want with them. Yeah, Commissioner Herr?
A couple additional questions that came up based on the public comment. I'm not sure I understand what happens and what has to be reported after the initial time a person becomes an expenditure lobbyist and has to make a $2,500 disclosure. So I understand that they would continue to have to say what reportable activity they had in subsequent months, but it seems like they would have to report in subsequent months even if they didn't reach the $2,500 threshold. Is that right?
Yes, as we understand the language, that is the case, that because it contemplates a registration rather than a simple reporting requirement, that's exactly the outcome. Now, the way that we proposed it in the draft forms is to enable, if somebody registers and then for that month they report, they could also check off on that report that this is their termination because they have nothing further to report, or they can just simply report 0. But as long as somebody is considered registered, it sounds to us very clearly that the ordinance assumes people will provide reports for every month following their quote-unquote registration.
I'm not sure that's what we intended. I mean, so basically you're saying, I'm a nonprofit, I spend $2,500 in this month because I'm doing this specific activity. Mm-hmm. Every other month, no matter how much, if I spend $50, I need to disclose the total amount and any payment of over $1,000 during that. So you have to track your time for every matter going forward in every month and report that, even if it's not $2,500.
Yeah, so to get back to this issue about this continuing obligation to do monthly reports, I think that's fair. It's pretty clear that's contemplated by the ordinance. As you're all aware, the expenditure lobbyist ordinance was modeled after our existing contact lobbyist ordinance. And that is a model or a scheme by which once you initially qualify, you must register, and thereafter file monthly reports until you take an affirmative act to terminate your registration.
Okay, but am I right that no matter how much you spend in that subsequent month, you need to be tracking and reporting it, whether it's by specific matter or whether it's aggregate? And if we're going to require employees to keep track their time for, that all would have to be disclosed,
that's
even if they didn't hit 2,500 in the subsequent months.
Yeah, so that's correct. So if it is going to be the direction of this commission, and it doesn't sound like it's determined yet,
sure,
that there would be a need to track pro rata staff time, it would exacerbate those administrative challenges, if I understand your comment.
Yeah.
It would just make it even more difficult because there's this ongoing obligation to report.
Okay. Okay, well, that sounds like a big concern. The other thing that I hadn't quite appreciated until one of the public comment is I like this idea of, maybe you didn't think you were going to use this study for lobbying on day one, but sometime later you do use it for lobbying, and I understand why we want to capture that. But and maybe this goes, again, back to the staff time issue. How does the nonprofit, they have to track every single thing they do that could potentially be used for lobbying, because if they don't, how are they going to go back and determine how much they spent? I hadn't quite appreciated how difficult that would be. So while I like this idea of a lag and making sure we capture some lag, I think we need to figure out how to address that issue. Thank you.
There are no other comments by the Commissioner. Let's move to item 5. Discussion and possible action regarding the assessment of the city's whistleblower protection ordinance. And in this regard, I want to thank Commissioner Herr, who, when this issue first came up in maybe the middle of 2015, I asked him as a subcommittee of one to look at it and come back with a recommendation, and that's what we have before us. And I guess I want to thank Commissioner Herr for the work that he did on this. I think it's a great job, and I'll let you make whatever comments you want on your proposed changes to the whistleblower.
Thank you, Chair Rennie, and want to thank former Acting Executive Director Jesse Minardi for his efforts in this too. The idea was to take the grand jury report and really analyze it and take it seriously and try to figure out what we can do to make this ordinance better, because I think the civil grand jury had some very good points, and we tried to address them. I do, however, recognize that a lot of people in the public have strong views and views that can help make this proposal better. So the idea is to hear you today, figure out what we can do to make this memo better, and then come back with regulations hopefully next month.
So that it can be Commissioner Herr's swan song at his last meeting. Do any of the commissioners have any comment on the draft? I had the one question is the requirement that it be in writing, it not that oral is insufficient. And I'm just, you want to give me the thought process of why you require it to be in writing?
It's mostly because of the section 4.115A, which says that a complaint which contemplates a written complaint. I think that the term is written complaint to your department, if you are making one. So in that regard, it seemed like that was what the provision.
Aren't you proposing to broaden it so it isn't just limited to making a written complaint to your particular agency or group, but making a complaint, say, to some other government?
Sure. It also contemplates making a complaint, for example, to the Ethics Commission or what have you, but if it refers to filing a complaint. So I've never heard the term filing a complaint used in an oral context. So I do my interpretation is that when they're saying filing a complaint with the Ethics Commission, that's something in writing, and I'm not sure why we wouldn't want that or what the deterrent is for filing it, right? There shouldn't be a deterrent to filing something with the Ethics Commission in writing. It's not like you're worried about some sort of additional retaliation, I would think. And if you're required to put it in writing to your own department, I don't see why it wouldn't apply more broadly. There are, this does contemplate oral representations that are made, for example, during an investigation that's done by the Ethics Commission or the city attorney. So if we're conducting an investigation, we interview someone, they make oral statements, and they're retaliated against for those, this would cover those kinds of statements.
Did you have any occasion, or did Mr. Minardi have any occasion to talk with the Controller's Office, who also has the hotline, whistleblower hotline, and has responsibilities in this area, as to any thoughts they might have on your proposed changes?
He did talk to them, and I think we referenced some of those conversations in here, or some of the overlap. I can't speak to on every issue what their view was.
If no other comments by the Commissioner, I'll call for public comment.
I'm distributing this handout for the Commissioners and a copy to Ms. Pelham. I'm Patrick Monette Shaw. I've never shared this with you, but I am a victim of retaliation for having used First Amendment free speech rights while I was employed at Laguna Honda Hospital. If you'd like a very brief summary of that at the end of my time, if I still have a second or two, I'll explain it to you. I support most recommendations in the proposal presented tonight. Recommendation 3 indicates the Ethics Commission may authorize cancellation of retaliatory job actions, but doesn't expressly state that the Ethics Commission will be able to reverse unlawful retaliation job actions that have already occurred. This distinction involves the difference between canceling a pending job action versus reversing an action after the fact. The answer and analysis accompanying this recommendations wades into whether reinstating a whistleblower may involve bumping a series of employees to their previous positions. Judge Claudia Wilkin was concerned by this difference in Dr. Derek Kerr's wrongful termination lawsuit. Under restorative justice, bumping concerns are completely moot. Recommendation 4 addresses portions of Campaign and Government Conduct Code Section 4.115, but ignores Judge Wilkins' concern in Dr. Kerr's termination case that 4.115A provides no protections for exercising First Amendment free speech rights, which this commission must fix. I am just, as I testified to the Board of Soups Government and Audit hearing September 3rd on the Civil Grand Jury report, city employees expect this body and the Board of Soups to amend the WPO to include First Amendment protections for city employees. Here we are 13 years after voters passed Prop C in 2003, directing the Board of Soups to enact a meaningful WPO. For over a decade, basic First Amendment rights have not been added to the WPO. It's long overdue, and I urge you to amend the recommendations to incorporate First Amendment free speech protections for city employees. The reason I was retaliated against at Laguna Honda, I was writing a newspaper column after hours, on the weekends, First Amendment, free speech rights, and every time a new issue hit the press, Director Katz would call the Laguna Honda administrator. My boss would fly into my office, slam the door, ask me to tone things down, and I'd say First Amendment, free speech, after hours, and on the weekends. No, I'm not toning myself down. They eliminated my classification code, and I lost $20,000 from that process.
Thank you.
I'm Bob Planthold. On behalf of Friends of Ethics, I recommend to you the 7-page memo that we sent. I'm not going to go through all of that. We definitely think 2 points ought to be stressed. One, the dollar value raised from $5 to $10,000. It still ought to address the question of attorney's fees, because to prosecute on the complainant's side, a complaint may need legal counsel if one is retaliated against. But there's another issue that I want to suggest that you're missing the point by saying it's got to be in writing. So I'm going to give examples from the time I was on ethics. Not everybody works for the city or as a contractor is really good at writing English. Some people have a 6th grade education, and if they wrote out something, the very fact of their simplified phrasing might tip off somebody in the department who it is, because they've heard that person speak and use that phrasing. So the question of writing can out a whistleblower. Similarly, on the very last night of my term, after I left the meeting, I was approached by a person who was not fully fluent in English. And in halting English, for 20 minutes we sat on a bench and he told me of a problem. I tried to get him to go into the commission office the next morning, but he was afraid to be recognized. He thought I'd be the reporter for him. In an earlier situation, one person actually came into the ethics office and asked them to help him write the complaint. So I don't know if staff feel they can or should do that, but that may be an alternative, but you're still going to need translation services. There's another problem with putting it in writing, and this was a story that made the newspapers. A person said she wanted to make an anonymous complaint. She came into the office, she filled out the form had at the bottom a signature block. She thought in order to get the complaint dealt with as a formal matter, she had to sign it. The interpretation by staff was, by signing it, she did not seek anonymity. There was no distinction in the form that signing it means you're getting this filed, or signing it means you're willing to make it public. So you've got to be very careful if you're going to say anything about having it in writing, but having it orally submitted just seems appropriate also, considering some of the people in this city are not fully fluent in English or may not write well and could risk being outed by writing in their limited language capacity.
Thank you.
Commissioners Ray Hartz, Director, San Francisco Open Government. I agree with Mr. Planthold. This city has a significant portion of people whose language is English is a second language. Some are not fluent in English, and some are not even able to speak English to any equitable degree. So saying that there is a writing requirement for them is putting an undue burden on them. I think it's actually, it could be called an Americans with Disability Act. What if I don't have hands and I can't write? I mean, I'm not trying to be ridiculous, but the bottom line is there are a lot of reasons why insisting that it be in writing is not something that is a good idea. The second thing about the confidentiality, this city is notorious. I myself have gone before the task force, or at least 40, Sunshine Ordinance Task Force, 40 times. The first 5 or 6 times I went, I put the little box where it says, do you wish to remain anonymous? And I checked the box. And within a week, the person I was filing the complaint against let everybody know, wrote a letter to the task force saying, Mr. Hartz's complaint, da-da-da-da-da. So it has to be both sides. It can't be simply, I have a little form I sign, I want to be anonymous, and then the other side is perfectly free to let the cat out of the bag. I myself was a subject of a similar retaliation. I worked for a very large national company here in San Francisco. I called their human resources office in New York, which was supposed to be a confidential line, gave them a rundown of the problem I was having, and my area supervisor was in my office the next day wanting to know why I was calling New York about him. You can't have a program where somebody is asked to come out and put their reputation, their name, and sometimes their physical self on the line to improve government, and then put them in a position where there may be no confidentiality at all. I watched the case with Dr. Kerr. He did everything he could in-house, and then he had to go out of house, and basically the health department treated him like a dog. And there was absolutely nothing he could do about it except go to court, and then the city ends up having to pay him $350,000. I sometimes honestly wonder what the city attorney's idea of protecting city is. Is it protecting the city by making sure that all of its employees and committee members and so forth follow the law so that they're not in trouble by breaking the law? Or is it to simply find a way to excuse the fact that when they break the law, that they had an excuse? As far as free speech goes, I know what the answer is. Stop him, and we'll find some way of explaining why it was okay.
And this is a matter that I did not expect that we would make a decision on the recommendations tonight. It will again be on the agenda in February for final implementation, and any further input that the commissioners may have to the staff, you should make them. Okay? All right. Turning to item number 6, discussion and possible action on proposed Ethics Commission budget. And I compliment Ms. Pelham for a very interesting and informative discussion of the budget, but take it these are recommendations for considering either at this meeting making some final determination or putting it off to February 22nd, which is after the time which you have to submit it. Do you want to address this question?
Well, yes. I think this budget document was intended to provide the Commission and the public with my best estimation of what I believe the Commission needs to be right-sized. It is a very ambitious budget document, of course, and it speaks to a variety of priorities and recommendations that I would look for any input that you have, feedback, good, bad, or otherwise. My hope would be that with that guidance, having had a chance to look at it and perhaps talk about it in more depth this evening, that we will be able to submit specific budget document as requested by the Mayor's Office of all departments on the 22nd. Again, depending on the feedback that you all have, that is something on the 22nd. If there's additional comment on or feedback, we could amend what we've submitted. But my hope would be that, that there would be some general consensus that the requests that we're looking for be submitted as requested by the Mayor's Office. Now, this document also does, in addition to being ambitious, it does identify if all departments are asked to cut the 1.5% this year, we've identified where we would have to do that, as well as for the following year. But as I said, this is a document that's meant to be really a blueprint that we will be building on, assuming that there is not an opportunity to build it all in 2 years. At least it would lay out some of the key areas that are essential for us to start doing our work in the most cost-effective way, in the smartest way possible, and bringing it into the 21st century, certainly with some of the technology issues that we talked about in the package. Just as an overview, if you turn on pages 3, 4, and 5, pages 3 and 4, outline what some of those priorities were. An e-filing conversion project that really speaks to bringing all of our public disclosure processes into 21st century, using 21st century technology. We have identified and submitted to the COIT, which is the city, the Committee on Information Technology, a request to start doing this through project development, to start project development and implementation for an e-filing conversion project that would create a template for people to more simply comply with the requirements that we have. And that involves also some additional staffing that we would need to help accomplish that. A second priority is in terms of effective investigations and enforcement. We do have one position that's not been fully funded. We would like to be requesting that the organization is able to retain the balance of funds that would be necessary to fully fund that position. We've been giving those up through attrition savings in recent years, but if we were able to keep that, we would be able to fill that position that's been vacant for too long. And that's also critical for us to be able to deliver on our investigative and enforcement mandate so that cases can be examined and resolved timely and thoroughly and effectively. As you can see, we also note that there would be an additional position to serve as an investigator, sort of a more junior level, and then some funds to help us with the resources that we need to do the job that we have with existing resources, but that need to be enhanced if we are able to do more enforcement. Thirdly, and I think this is a really quite an important area for the Commission, and I think as the discussions tonight are evidencing, I think it's critical that in some way we are able to develop a focused policy effort or function or team within the organization. We have a lot of very skilled and experienced and knowledgeable staff. What we currently are not organized to do is to provide you with a real robust policy focus, because we simply are not organized to do that and we don't have the staffing to do that. So this is proposing that we are able to create a unit or a team of individuals that would provide public policy analysis and compliance outreach to help people really understand the laws, that would be able to bring a lot of the feedback that we're hearing into the policy development arena, that would be able to harness the administrative work that we know and the enforcement work we've attempted to do into shaping public policy at the front end. And then finally, the administrative support and transparency area. I've listed here some areas that we wouldn't require new funding. We do have a vacant position that we would fill. There's no new funding requested for that. I would like to be reclassifying a couple of positions to provide us with a higher level of work that can be done by a reclassified position. And so those are the two other areas that you see here. My view is that if we are able to right size and realign our positions, we will be able to meet the administrative support needs that we have more effectively, and we, coupled with the ability, the potential of doing more of an electronic filing, online filing framework overall, we would be significantly reducing the amount of staff time we're doing to administer projects. We could provide much more helpful support to the public and others who need public information from us, and also to provide administrative support through all of the work that we need here in our meetings and to you all as a commission. So that in a nutshell is the package of recommendations that I wanted to outline. We also provide some basic information about our current snapshot. I think one of the things that is important in this document, as I said at the introductory meeting, I think on the January the 5th, as we go forward putting any package together for submission to the mayor's office, it's very important from my perspective that we give as much detail and documentation, supporting documentation and justification for these requests as possible. This document is an overview, sort of a policy view. Does the commission have this policy view of where we would like to go? And if so, would plan to move forward and put together the most solid data to back up the recommendations with the information that we have to help the mayor's office and others see the need for these resources. So that would be the plan going forward, but I wanted to find out your input and your reaction to this. It's obviously very ambitious, but it's, I think, the direction, from my estimation, that we should be heading in order to actually deliver most fully on the mandate that the voters have set for us.
Mr. Keene.
Yes, thank you, Mr. Chair. I want to compliment our new executive director for doing an excellent job, long overdue, in regard to submitting a budget that actually does the job of the Ethics Commission to the best extent that it could be done, rather than just sort of going along in a rather lackadaisical way with whatever the city wants and the commission not being able to carry out many of the functions that are necessary. I think it's clear from all of us in terms of just what's going on in San Francisco, what we read in the newspaper, who's being charged with crimes, that San Francisco has developed in the course of the last, a couple of decades, a fairly widespread system of soft corruption, and that has not been addressed by this commission. One of the things that the mayor said the other day, in being shocked at 3 people who were charged with corruption by the district attorney, is that he would not tolerate any type of pay-to-play type situations that most people believe are really prevalent throughout the town and have been for a while, and he simply was going to do everything in his power to make sure that doesn't happen, and that San Francisco should not turn into this kind of soft corruption that's been going on now for quite a while. If that's the case, then, Mr. Mayor, you should pass our budget, our fully funded budget, and give us the tools to address the kinds of corruption, pay-to-play that you say should not take place here. Again, this does it for us. It's a full amount for what the executive director, in my opinion, has outlined as necessary to do the task. I think we should push it as hard as we can with the mayor to go ahead and fully fund this commission, to do all of the jobs that you've identified that need to be done. And the idea of a cut is just totally a disgrace to any aspect of San Francisco having any show of honest government whatsoever. So I want to thank you for what you've done.
Mr. Chair, so Ms. Pelham, I do want to echo Commissioner Keene's sentiments. Really a well pulled together document, very clear, and I appreciate it. A couple things I wanted to just have some confirmation on as we deliberate on this budget proposal. So basically, e-filing, effective investigations, and proactive policies is generally capacity building. We're in capacity building mode. That's what it represents in year 1 and year 2. You would happen to know, you may or may not have done this calculation, the percentage increase from the current budget year to a proposed budget year, and do you know that percentage increase?
Overall?
Overall, if it all went through in capacity building, what would it be, like a 10% increase of the budget? It's 2.5. Some of these are in the hundreds of thousands, I'm sure.
Yeah, it's roughly a 30% increase.
30% increase?
And that does include the bargain we're getting at administrative support for a savings of $15,000.
$15,000, which I saw, and I was going to get to that.
But yes, that is, it's roughly a 30% increase.
Over 2 years?
In our operating budget for the first, for each of the 2 years. And not a 60% increase. It would be a 30% increase over this year's operating budget.
Got it. Oh, but that would cover the next 2 years, though, I'm assuming. I think. That's what we're headed for. So are you, another question, are you able to do under administrative support and transparency what you would like to do if we took the most conservative, if we listened to the mayor and we took the most conservative position and submitted reductions of 1.5 in 17 and 1.5 in 18? Can you still do all of what you were looking to do under administrative support and transparency?
No, we wouldn't. We would be able to, in the first year, we would be able to accomplish essentially the first 2 bullets. The third position, the reclassifying one existing junior management assistant, that would happen, and Shiesta, correct me if I'm misstating this, that would happen in FY 15. Am I correct on this, or am I getting this confused with another position?
Well, we'd like to do.
Yeah. Shiesta, I could assist.
Well, we'd like to do this as soon as possible, but I think here we're proposing it for the upcoming fiscal year.
So 16.
So for FY 17.
Yeah.
So this would be, so what we would have to give up in the second year, which is eliminating one of the 1840 positions. We currently have a position that's been providing administrative support that's on a 3-year basis, and we have 1 more year of that 3-year cycle. So at the end of that, which would be the beginning of year 2, we would not be able to use that position to reclassify it.
I say that because I wanted to make sure, at least even in a tangential way, that even this category, we would have to take a position of capacity building. I wasn't sure if we took a conservative point of view and you thought that in a modular way you could actually do this last piece, that would be great. But as it turns out, all 4 components of it are really needed if we took the position of putting forward the budget that we think we should put forward for fully funding. So that's fair. And so to me, and then the last thing I wanted to ask about was thoughts around the $560,000 that was kind of set aside for Prop C. Did you want to say anything about that, or did you have any thoughts about how?
Well, I think as I note here, it isn't something that is part of our operating budget.
Right.
The funds are there; they were intended for an electronic filing system for Prop C implementation. So I think the one question for the tech people as well as our legal staff in the city is to what extent could that 560 be used for e-filing projects that are not per se related to Prop C, and is that a fund on reserve that has any flexibility? And I don't know the answer to that question as I sit here. That's one of the questions I think exploring with the mayor's budget office and the COIT team and the city attorneys would be important.
It's a good question, and that would be great, as broad as they could get that would be great. And then the last question I have is, and if we take this position of submitting this capacity building budget that I would say that is in many ways mandated by our voters, did you decide, let's just say some funders fund whole, they're all or none when you submit a proposal, or some do partial. Are you, depending on where the mayor is, he could potentially come back with partial. Have you prioritized any of these to say, look, I'm going in for this, I'll probably get that, and in that regard, here are the areas that I think I would prioritize more over the other?
That is an important question, and of course, any budget is going to have to prioritize. I would say that the e-filing conversion project we have expressed to the COIT office is our #1 priority as an organization. I've taken that executive liberty to say it right as I see things right now. Unless and until we can free up our resources from doing paper processing, we will be continually in the 20th century and unable to do much of the work that we have to do. There's a trickle-down effect, maybe it's trickle-up. When there is paper processing to be done, that takes resources away from people who might otherwise be program administrators. People who are administering programs right now are doing other things, including investigative work. So if we were able to at least, at a minimum, start tackling this, we could begin to start freeing up other resources to do some of these other pieces of work. That said, as again, I want to emphasize from this evening's discussion, having additional policy resources is going to be critical for the volume of work and the breadth of the work that this commission needs to look at in the coming couple of years. That's going to be critical as well. I'm hopeful that with a hiring of a position that we currently have allocated, which is the deputy director position, all of this will also help us in both investigative and policy work. But again, your term capacity building is absolutely on point. That's really what that we have to, in my view, that we really have to be driving home, and we really have to try and increase in order to do the work we have.
And to just be clear, in when we're framing this with them, this is capacity building to get to an optimal level of functionality for the department.
That would be my view as well.
It's not that we just want more. We just need. We've been lacking for quite some time. I will push for my commission secretary later. I see that it didn't find itself in here, but you're telling me that if all of this played out, that in many ways there would be administrative time freed up in order to do all of that, and that you feel comfortable as our executive director that would be the case.
Yes, and I also think that in looking at some of the topics that or areas of responsibility that an executive secretary position ideally fills elsewhere, part of my reaction is you've just hired an executive director to help the commission do that. Public outreach, supporting your needs, making sure there's information flow between the commission and the staff. So there's a variety of things that I think we can do to address that in the coming years and see where we are 2 years from now.
Okay. My last point. If there was a way in which we could create a cogent argument that is rational and within the bounds of Prop C of the 560 that really could address some of the e-filing conversion project, that would be great. In which case, I would sort of, I'm not sure who you would have to go to in order to talk to about that, but really get an understanding of that, because as that could be solved, it helps you kind of recalculate the cost savings that you could have, and kind of reorg this so that you could get as much as you possibly could in our initial ask. Yeah. All right. I think it's great. Thank you.
Reiterate my appreciation for your hard work on this. Not an easy job, the first thing in, and a lot of things that need to be done, and you've done a great job of addressing most of them. Is Stephen Massey back from his leave?
Soon. Not soon enough, but soon.
Have you had a chance to talk to him about the...
Yes, I have. Yeah, I had a chance to sit down with each of the staff the very first week on board, and I have to say that was tremendously illuminating, very encouraging, and a lot of thought that was the basis for this.
Okay. And so this $250,000 project development, how much of that is expense that you think will be paid out that's non-staff?
Well, that's a good question. I think this is a rough estimate, and I don't know that I have a specific breakdown. This is probably the development. It's probably through the development of external programming and support to develop an overall system. So we'd have an internal IT staff to help develop and design scope and so forth. But this work would actually be done by probably the external people who are helping to design the system itself, or upgrade the systems if they can be upgraded to expand to these other, beyond the current electronic filing systems we have.
Okay, so most of this project development and implementation is going to be paid out to...
That's my sense at this point.
Entities, okay. Okay, and then I think you alluded to this, but on the enforcement piece, are you contemplating your deputy being a director of enforcement, or are you contemplating the deputy as it's traditionally been staffed at the commission, and how does that affect how you're budgeting for effective investigations and enforcement?
The deputy director position is not included in this. I envision that they will have a very strong hand in working with the enforcement program.
Okay.
This is not assuming any of those funds that would help that program, because in fact there's a broader role they'll be playing, but their primary focus would be probably on managing and working with this entirety of staff more directly than I would.
Okay. Last question. So going back to the proposed cuts, again, and I think you may have answered this for me last time, but if you don't make a proposal, then what happens?
Well, my experience is that if you, and I think we heard this from the mayor's budget office, which I think is a fair statement and assessment on their part. If departments do not identify cuts, and if that is the choice that the mayor's office would make in identifying, they'll identify cuts for us. Mm-hmm. My philosophy and view and experience is that if there is a cut to be made, the department is always in the best position to identify where that should come from to minimize the impact. So, for example, if a cut were made, a reduction of $39,000, and this is a figure from the mayor's office. It's roughly about $39,000. The area that it would impact is our campaign finance and compliance assistance, and for FY17, it would be an elimination of all the part-time and as-needed funding that we would have to otherwise bring in temporary staff to assist during that cycle. In FY18, I think I alluded to this earlier, that would require a cut of $78,000 and some change. That also is in our campaign filing area and compliance assistance area, and that would be the elimination of one position that's considered a management assistant type position. A position 1840 is the classification, and that's, as I mentioned, is currently it is currently a 3-year project basis position. Our hope would be that we could use that position to reallocate it for an e-filing conversion project or e-filing support position once it expires. We would then, if we were forced to cut $78,000 in FY18, we would not be able to use that position. We would eliminate that position.
Okay, so
after the 3-year term has ended.
If the mayor gives us more than we had last year, this past year, and some of these, the requests that we're making are implemented, I presume these cuts don't apply. In other words, if we get more than last year, then we're not even worried about or thinking about these cuts, or are we?
I know. I think if we're able to be successful with some of our budget requests, we wouldn't be looking at having to cut these two positions.
I know that sounds like a strange question, but I'm wondering, given how aggressive our budget is, and I think it's appropriately aggressive, why we even have these in here? I mean, if we're actually going to get cut from this year to next year in light of all that we have to do, I mean, it would be very surprising, and also I don't know that we want to make it easy for us to be cut, given that what we really need is a pretty large expansion. Mm-hmm. But I'm not as savvy on the budget issues as
could I follow up on that? I think that's an excellent point. And strategically, that is key here. I think we should just go for an all-or-nothing type situation. If we outline, okay, there are these ways you could not give us what we're asking for. That's what they're going to. That's what's going to happen. So. Commissioner Herr put his finger on one of the primary aspects of budgeting in regard to what we're trying to do. Let's tell them what we need in terms of the totality, as you have quite well here, and what we're using it for, and then leave it at that. Don't suggest ways to make it easy for them at all in any respect to cut. Later, if it comes around that they're going to cut, then they're going to tell you what to make the decisions anyway. They're not going to make the decisions themselves. That's baloney. Or they say, if you don't make the decisions, they wouldn't know what to do, and it's not going to happen. So just ask for the whole enchilada.
I have to say, I'm almost there. I'm almost there with you.
Be there.
I'm bouncing around the idea. Maybe we follow the instruction. Maybe we overfollow the instructions. We submit 2 budgets. We submit a cut budget.
Tell them what we need, for crying out loud.
Okay. Well, and I will say this, and the fact is, I mean, even though we're talking about a 30% increase from kind of year over year, over the next 2 years, the fact is that they're looking at the real number. At the end of the day, the budget office is going to look at the real number. And if the Department of Public Health went with a 30% increase, that's a $2.2 billion outfit. That's a large number out of general fund, right? But if it turns out that this is important work, and it's important work that is only going to cost us $300,000 as compared to whatever other city departments are submitting, Parks and Rec and all of the others, well, then that's a really big bang for the buck. So it goes back to us. Our role and responsibility, our burden, is to make our case as best we can for why you would want to spend that $300,000. This is a good investment for you. And $300,000, money is money and every dollar counts. I'm in nonprofit, I totally get it. But in terms of the larger city budget, it's a rounding error. It's less than a rounding error. It's probably immaterial in how they are balancing their budget, but I think it's important for us to make our case.
Commissioners, if I might, I had one of our staff members today pointed out that they had recently remembered a 2013 article, I believe in the Chronicle, about the city and county purchasing muni buses, and the cost of one muni bus was roughly $730,000 or $740,000. So again, I think your point is exactly right. It is a large percentage increase because we are small, and we have been flat for almost a decade. But in the larger scheme of things, it's the cost of a muni bus.
And in light of what is going on right now and this heightened level of corruption that's happening.
And just in terms of the city saving money. I mean, if by doing this, the whole perception of the commission is that people who try and fool around with campaign finance reports, sort of shave it here, shave it there in order to give phony types of reporting for contributions and payoffs. If that doesn't happen, and as a result of that, those people are not charged with crimes, then the city doesn't have to go through paying all of the money to prosecute and investigate and do other things that could, in the long run, turn us into a money-saving operation for the city, not to mention the whole aspect of morality and honesty that really are the overriding things.
Well, I would say that Ms. Pelham and I met with the mayor, had a good half-hour, 45-minute talk about the commission and how could they be helpful to us. And I also sort of told him that we weren't really trying to confront him with the budget, but that we had concerns. And so I don't have any problem with the idea that we prepare a budget that we think is consistent with the vision that you're talking about, and submit it, and maybe in advance of our submitting or at the time we do, see if we can get another meeting with the mayor to say, this is what we've done, and we really, and all they can do is turn us down.
Exactly.
So do I hear a motion as to direction of, I will.
Yeah, I move that we go for it.
Do I have a second?
I'll second.
All right. Public comment?
David Pilpel again, speaking as an individual. I'm sorry I missed some of the discussion. I was in a meeting down the hall. I do agree with the motion. I think the technical term that Commissioner Keene just used is that I move that we go for it. I like that. I think you should ask for what you think you need and let the chips fall where they will. I think it's important for the staff to provide the technical numbers and the narrative that the mayor's office needs for the budget process, but I think it would be also helpful if you would craft a cover letter, perhaps from Chair Rennie, encapsulating some of what you just said about meeting with the mayor and attempting to expand the capacity, et cetera, and perhaps also include reference to the health department. That's, as you say, billions. A small investment here actually reaps great rewards. So I think you make the case to the mayor. Depending on where that goes, then you make that case or a slightly different case to the Board of Supervisors, and that's the process. I'm not sure that the Commission's going to get everything that is asked for here. But if you make incremental improvements, and instead of getting, what's the ask, 780 or 700,000, if you get $500,000, look, $500,000 would go a great distance too. So I think it's whatever additional resources you can get to meet the staff needs, the public priorities, and the commission priorities. And I'm glad that you had a chance to meet with Stephen, because I agree, Stephen Massey is really key to everything around here. We love Stephen. Come back, come back. Anyway, so those are my thoughts. But again, I think if you authorize the chair with staff to craft a cover memo, I think that would be helpful to both include with the submission, put on the website, make clear not just what the plan is, but your sort of joint view on making that happen. And then just finally, if there is anything that happens in the subsequent month, your next meeting is on February 22nd, you might have a need to tweak, and if so, you can always bring something back to the commission for the February meeting. I'm sure as long as you get the technical stuff into the mayor's office, if you have a tweak at the end, they will normally just accept that and deal with it one way or the other. So, thank you.
Thank you. Any other public comment?
Well, it's often said, this is Larry Bush from Friends of Ethics, I'm speaking on behalf of Friends of Ethics, that budgets are policy statements. And for the recent past, the policy of the city has been, don't do the things that the voters have told you to do. And you can see that in the Controller's report about the Ethics Commission, that only about 50% of the complaints that come into the Ethics Commission are resolved in the course of a year. And in fact, in that report, it says that in 2 years, it will decline to 48%. It's a very troubling statistic to say that the complaints are not going to be resolved. So in another context, it was also said that the mayor proposes and the board disposes. And so I think that you certainly have a place to go with the Board of Supervisors if additional funds are needed beyond what the mayor would propose. But this is an excellent document. It begins to pick up some of the pieces that have been missing. It's true we don't have a commission secretary, and I will still make an argument that there should be one. But in the meantime, with the policy statement, you're coming very close to what the charter requires of an annual report on the efficiency of San Francisco's laws and what needs to be done. And that has not been done in 20 years. So you are picking up pieces that have been laying there, but which the voters told you to do and you didn't have the resources for. So I thank Ms. Pelham and the Commission for moving forward with it.
Thank you.
Commissioners Ray Hartz, Director of San Francisco and Government. I agree with Mr. Bush in the sense that the budget and a lot of the other things that happen administratively are a very clear policy message. And in the fact, since 2008, when we had our second worst economic crisis since the Great Depression, the city budget has picked up fairly rapidly, and I've watched all the departments ask for more money and get more money. And yet, for some strange reason, under the former executive director, the budget stayed flat. And I think that sent a pretty clear message that there was really no intention of supporting the efforts of the Ethics Commission. And I'm very encouraged to see that both the Commission and the staff are looking forward to what is it that voters want us to do, how well have we been doing it, and what do we need to do as far as resources, in other words, to move in the direction that the city needs to move. It really does become discouraging. If you ask most of the, I don't even, what's the thing, not millennials, but whatever, most of them don't want to be involved in politics. They don't even want to bother to vote because they figure politics is just something that is intractable, it will never be changed, it's dishonest, it's whatever. And the Ethics Commission is a place where people can bring concerns and get answers, and also what Mr. Bush mentioned, the fact that the cases seem to do. Very honestly, in the past, I've tried to file a couple of complaints with the Ethics Commission and met with nothing but resistance. I mean, it was just made very obvious. Oh, well, why don't you go over there and file it? Why don't you go over there and file it? I don't think there's a basis for a complaint here. I mean, if you have your investigators or the people who are supposed to be investigating the complaint you want to file telling you all the reasons why you shouldn't file the complaint, it doesn't make you very confident that the investigation will be one of any effect. I think one of the things, and you probably may not have thought of it, maybe you did, but it's certainly one I thought of, is let's put Mayor Lee on the spot. There's a lot going on in the news right now, and I think most citizens of this city really do feel we have a fairly corrupt system. And there's, it's such a large system, what, an $8 billion budget? You can have a lot of corruption in there for $8 billion without it becoming a major player. But the bottom line is let the mayor show his true colors. You need to have the increase. It's been flat for years. Everybody else was getting increases, and now you're asking for just to catch up. And let the mayor decide whether or not he wants to make a statement to the public that I support the Ethics Commission or I do not. And this decision is one that he alone can make. And he, given his own position regarding some ethical questions, needs to be very clear.
Thank you.
Good evening, Commissioners. I appreciate the late night. You've been working on this. It's been a big day for you. And interesting, I've been watching you on television enjoying my Haagen-Dazs. I'm sorry
cruel.
To say.
Yeah, that is cruel.
But it was coffee. I just thought I'd let you know, so I'm perky. I did want to say, though, that on the budget, you did a great job. The staff obviously has worked very hard on this. Your executive director has done you well. We clearly flatlined in 06. And I think you're in a very good competitive advantage in the mayor's office because you can show how you've leveled off on your funding. And now we need to bump up. We have a new era. We also have a lot of international money coming into the city. And I think the allegations in the press and some of the latest developments put you in a good position as I think the public would agree and would support a significant increase in your budget over the next 2 fiscal years. I would not go to the mayor's office with proposed cuts. I would go in full force, as I hope that I will see you do tonight. And as I say, I think he would be a fool not to give you deference in this session of the budget. This next 2 fiscal years, I think, are going to be a slam dunk. So, on that good note, I'll ring off.
Thank you. I will call the question. All in favor of the motion?
Aye.
Aye.
Opposed? Motion is carried unanimously. Turning to item number 7, discussion and possible action regarding the Ethics Commission's referral to the Bureau of Delinquent Revenue of Forfeiture concerning Supervisor Mark Farrell. And I guess the first question, do I hear a motion that we should?
Point of order, Mr. Chair. I object to us taking up this matter. We have finished with this matter. We litigated Mark Farrell's illegal campaign contribution. We made our findings relating to his illegal campaign contribution. And we also came up with the penalty for Supervisor Farrell for that, his taking an illegal campaign contribution through a committee that was a sham committee that they were coordinating with. All of that stuff is done. There's a collateral estoppel aspect here. It's clear on the face of this in terms of the attachments, What's being asked of us as a committee is to relitigate it in some way. The last words that I remember when we went through this and went through a full litigation of it is the chair saying, well, it now goes to collection, and it is out of our hands. And Mr. Chair, you are absolutely correct. We finished our task. I would submit that it would be totally improper for us to revisit this in any way in terms of what's before us. Essentially, what's before us on the open aspect, the attachments, are the same arguments that were made to us. Statute of limitations hasn't run. Well, he really didn't do anything wrong. Or if he did do it wrong, if someone did something wrong, he didn't know about it. We went over that exhaustively. This is, in effect, a motion for a new trial at this point. And I object to it. I think procedurally it's completely improper, and it should go off calendar.
Any other comments on that? That's your motion?
That's my motion.
Any second?
I'll second it.
Pardon me?
Second.
All right. Public comment?
Can I first understand what you hadn't even finished introducing it, so can you tell us what it is, and then so we can make an informed?
Well, the reason why it appears back on the calendar is because the matter, as you say, was referred to the Bureau of Delinquent Recovery, I think it is, Delinquent Revenue, which is in the Treasurer's office. Having met with the Treasurer, says that their procedure is that where to proceed on it is a determination of the Ethics Commission. They follow the agency, and that the determination to file a complaint or to proceed in that requires a direction from the city, from the commission, to tell them that's the way they want to proceed, and they will follow our instructions. And so that the purpose of this item is for a discussion of proposed litigation and how it should be handled.
And we've already told them how to proceed. We
send it to them.
We send it to them.
Believing, and if I said it's out of our hands, that may have been my understanding, but the Treasurer's office is telling me, no, it's not out of our hands. We are the ones who will call the shots as to whether any settlement, whether there's any, how it's going to be handled. And the Treasurer's office will follow our directions.
So, Mr. Chair, are you saying that the question before us is to tell them, yeah, go forward and collect it, use your efforts to collect it, or don't go forward and tell it to use your efforts to collect it?
The purpose is to give the Treasurer's office and the city attorney input as to how we want it to be disposed of.
And we did that. We said that the penalty was that Supervisor Farrell has to reimburse the city and county of San Francisco $193,000, which was the illegal contribution he took. If he has to reimburse it, he owes it to the city, so the city should be out there collecting it. We're not a collection agency.
No, but the point is he's asking for directions from us. There's been a communication from Mr. Sutton's office. indicating a willingness to want to talk about it. And he wants directions from us as to should there be communications with them? Should there be discussions about settlement? Should there be any discussions? Or should it just be, and he's asking for advice?
I think he's asking us to do his job then. They're the collection agency. I would imagine that in regard to any debt that they go after, they've had mechanisms in the past to demand the whole thing, or perhaps get it in installments or settle for less. That's not our job, Mr. Chair.
He has told me that it's the agency who is seeking the debt that controls the disposition, not the Treasurer's office.
So what is it we're being asked to do?
To give him directions.
Okay, I don't think we need to go into closed session for that. I think we should direct him, in accordance with our findings from before, to go ahead and collect the debt. And that's my motion.
All right. What? And you seconded it?
Hold on. What? I thought the motion was to take it off calendar.
Well,
now it's a different motion?
It is a motion to take it off calendar. I'll withdraw that motion in light of the chair's explanation, which, in terms of what the treasurer is saying to us, is totally bizarre. But if they want us to drop down the rabbit hole with them and to play an Alice in Wonderland game, fine. I'll go along and put it in that kind of language. And they need direction. They should collect the debt. That's my motion.
And then, so what role do we play beyond this? Like, if a decision that we would make tonight, like, do we play an active role along the way with the treasurer?
I think we should play any role.
And is this the normal operating procedure every time it's passed for collections?
Do you want to give any input into this, Andrew? But when you say, do we have anything more? Yes. What he's saying is that he's got a letter saying we want to talk about it, and he's saying, should we talk about it? We're the client. It's not the treasurer who's the client. We're the client, and he's asking us for any input as the client how we want to proceed. Now, you say proceed. Just tell him go balls out. That's some instruction. But I'm saying the purpose of putting this on was to give the commission an opportunity to decide what instructions, if any, they wanted to give to the treasurer's office as to how they should proceed.
I'm sorry, but that doesn't make any sense to me, with all due respect, Chair Rennie, as to we now have to be in the position of telling the city's collection agency how to go about the steps of collecting a debt. That's beyond our competence.
It sounds to me like he's not going to file a complaint unless the commission says that's what we want you to do. Because he's not paying the debt. The way to enforce it is in court. And so what I'm gathering is he's saying, Ethics Commission, if you tell me to file a complaint, then perhaps he'll file a complaint. But if we're giving him some other direction, try to settle the case, I don't know.
Okay.
Then that's what I'm gathering he's looking for.
Then I'd add a third motion to it, and that is my motion is that he files the complaint. I don't see why there's no reason whatsoever for us to go into a closed session on this. It would just give the appearance that somehow we're knuckling under to Supervisor Farrell, the chair of the Budget Committee, which gives it even greater appearance of sort of genuflecting to an instrument of power. We've already decided the thing. in a discussion that went on in a quite exhaustive and agonizing way. We had the public involved in it. As long as we don't go back into the merits of this thing, it's fine with me. But we've got stuff here from Sutton, who represents Supervisor Farrell, in which, if we get into, for one thing, he misrepresents the record entirely in terms of what we as a commission did. Are we going to get into that in terms of Mr. Sutton's misrepresentation of the record of what we did, and saying that Mr. St. Croix did indeed waive it, and then we overruled him? That didn't happen. That's an absolute lie by Mr. Sutton. And he points to a letter and says Mr. St. Croix said it in that letter. The language is not in that letter. Are we going to get into all of this again? Or what? Why?
So, go ahead.
Just very briefly, so I have the same understanding of what the Treasurer's Office is seeking from the Commission in terms of guidance as Chair Rennie has already described. This particular item was noticed of as a closed session because, as an option, certainly you don't need to go in closed session if you really don't want to, but to facilitate any possible discussion of the legal issues if you want to have such a discussion. And let me just also say, I by no means had it planned to make any lengthy presentation or to have a very long item or discussion about this particular matter. I completely understand the Commission's had many meetings and many discussions on this dispute to date, and I certainly understand the lateness of the hour. So you don't have to go in closed session. It just limits how much we can talk about. But if we do in closed session, let me assure y'all I will do my best to try to make the most efficient use of your time as possible.
Chair Rennie, a couple thoughts on this. One, if we're going to talk about what we should do in a litigation position as a plaintiff, I think we have to do it in closed session. I mean, otherwise that's core privilege. Secondly, this is a different procedural posture than what we dealt with last time. Last time, we were trying to decide whether we should withdraw something, a forfeiture request that was made by the executive director. That, to me, is a different procedural posture than whether and how to pursue litigation in a matter. I think it's a different standard of how confident you need to be in your litigation position. I think that what we went through last time was a pretty unprecedented procedure. This is a pretty standard procedure about whether to pursue litigation, and I think we know very clearly how and when you would want to go and do that. So I think it is very different. I don't think everything was fully decided in terms of what you would do as a litigation plaintiff in our last meeting.
I move my original motion that that this is out of order and it go off calendar. It's been seconded. Call the question.
Public comment.
Public comment.
Hi, Larry Bush from Friends of Ethics. As far as I know, it is unprecedented for the Department of Delinquent Revenue to send something back to this body or to any other body. You every month have a list of outstanding debts that are owed after having been fined by the Ethics Commission. Not one of those has ever been sent back to this commission to ask, do you want us to do something about it? Some of them are for as much as $6,000. They've been on the books for a year. Nothing has come back to this commission saying, what about these? What about these? What about those? Furthermore, in some cases, you have decided on a system of someone having to pay $1,000 or $2,000, and then from that point on, $500 a month. You never even get a report saying that those $500 months are being actually collected. Are they being collected? There's no report from them to you. And there's also nothing in this record that shows that they have asked you to do this. It's word of mouth. But nothing was provided to the public to tell us that they were asking you to revisit what to do. That seems to me that makes this an inappropriate issue for the commission.
Thank you.
I strongly agree. It's inappropriate at this time. I have Mr. Sutton's letter here, and if you read that last page for the letter sent to Stephanie Prophet Esquire, so she's an attorney. First off, I think the treasurer, or she should have advised the treasurer that this matter was coming up as a possible litigation issue to see what should be done. And if I was the treasurer, I would have sent back to you notification that we were going to proceed with a lawsuit to collect pursuant to what the law says, and that unless you hear anything to the contrary, please be advised that's what's going on. My view is that when Mr. Sutton requests, we therefore request dismissal of your original letter demanding $190,000 and ask that the city formally close this matter. It seems to me that they should have said you have to make that request to the Ethics Commission in a way that will reopen the case, and perhaps at that point it would be appropriate for Mr. Farrell to personally make that request, because everything is going through his representative. Even this letter, this exchange, it's never gone to Mr. Farrell directly. I would say that at this point, if Mr. Farrell wants to reopen this matter before you and appear here in person, then I would be very interested to see what he has to say. I would also be interested in your ability to talk to him and ask him questions, whatever those questions are appropriate or not appropriate, whatever you want to do. That's your right. But I'm thinking that at this point it's between Mr. Farrell and his conscience to raise this issue again before you, and that it really is inappropriate to be back in your shop. I think you should advise the treasurer that he should go ahead and collect a debt like he normally would, which would be to, in this case, I think, probably litigate it and then negotiate accordingly. Thank you.
David Pilpel again, speaking as an individual, and sorry to Leanne that you inherited this. It wasn't your choosing. This matter was discussed at great length at several past commission meetings, and I think I agree with Larry and Commissioner Keene on this one. What we have in the packet is a selective exchange of letters. There's nothing from the Treasurer Tax Collector's Office explaining what, Chair Rennie, what you explained earlier in terms of their procedures. I'm actually not up to speed on the code and their own internal procedures for how they handle debts of any size, including ones of this large. At a minimum, I think you should have gotten, and the public should see, a report from the Treasurer's Office on what's been done in the last 6 months to collect. Maybe there was an exchange of letters. I don't know what was sent from the Treasurer to Supervisor Farrell or to Jim Sutton, and whatever else there may be, and what other avenues there are to resolve this. I heard that there was a request to discuss and resolve the matter. I don't actually read that in the Sutton letter unless I'm misunderstanding it, and if there was some other letter, the public certainly hasn't seen that. I'm not particularly interested in relitigating the matter. I think that between the Commission, the City Attorney, the FPPC, that somebody got it wrong, and I actually think that Common Sense Voters is the entity that we should be going after, because they're the ones that received the contribution, and they should be made to forfeit. But that wasn't my call. To the extent that anyone made a judgment that it was Mark Farrell, then that's the judgment. But I would need to see more information from the Treasurer's Office on what's happened in the last 6 months and what the options are. I don't think this issue is properly framed for the public for tonight's meeting, so I'd agree with Commissioner Keene's motion not to take action tonight. Thanks.
Commissioners Ray Hartz, Director, San Francisco Government, and again, I have to agree with some of the previous speakers, and the bottom line is if the treasurer had sent a letter to this commission saying we cannot proceed until you tell us A, B, and C, and gave you some clear information as to what the problem seems to be, then it's really nothing the public has been noticed about, nothing you've been noticed about. It just sort of appeared on the agenda, and I would have to say honestly, under the Sunshine Ordinance, it's not even properly agendized, because there's nothing here really to tell the public what the heck this is all about. We're just going to have a closed session. We're going to discuss something. Now, as far as the relitigating this, or doing it in private, especially, again, we talk about that perception. We can't talk this in the front of the public because there might be a question or two related to legal issues. But every time I see people go into a private session, they come back out and say, oh, we're going to disclose? No, we're going to not disclose anything. And I wonder to myself, so you're saying that 100% of what you talked about in that closed session is nothing you can disclose? And that happens all the time. And it gives the perception of, well, we went in the back room and made a deal, and we'll come out here and try to justify it to you. The bottom line, he had his day in court. He had his many appearances before. He didn't have, I'll be honest with you, the integrity to show up and explain himself why he did what he did and why he felt that he was not responsible. He sends a bunch of other people who try to explain why they think he's not responsible. He's responsible. You found him responsible. Hold him responsible. And going into the back and having another meeting where you discuss, I'll be honest with you, I get the feeling from your discussion that you really don't know what the treasurer wants. So what are you going to do? Go back there and sit for an hour and a half and try to figure out what it is we have to do or say to the treasurer? I mean, obviously the treasurer probably does normal things. He files an order to pay the money. They come back and say, well, how about we negotiate? And all of that should be handled by the treasurer because that's what they're paid to do. If this isn't, well, number one, it shouldn't be handled tonight, definitely, because it is not properly agendized. There is not any information here that we actually have that we can see what the treasurer has said. Again, it is hearsay. And I'm not denying anybody's honesty or anything else. I'm simply saying the public has a right to know why the treasurer is raising this issue, because maybe we have a problem with the treasurer.
All right, let me, any commissioners have any comment?
I do.
Yes. Commissioner Herr.
So on this question of relitigating, I mean, I hope everyone knows that in order to actually enforce the debt in court, the matter will be litigated. It's not a relitigation of anything. This is that is the point at which it will be litigated. And what I'm also understanding from Chair Rennie is that the treasurer will not file a lawsuit unless he gets direction from the Ethics Commission to do so. So the result of not doing anything or taking this item off the agenda is that no lawsuit will be filed, is my understanding. So I'm a little bit confused, frankly, about what everybody is saying here, and especially in light of what you all had said in previous meetings. But that is my understanding of this agenda item, and what Chair Rennie has explained came out of a discussion with the Treasurer's Office.
Your discussion with the Treasurer's Office, or whose?
No, I did not talk to.
Well, how do you know these things?
Because I believe Chair Rennie.
Thank you, Commissioner. Let me just say, I'm going to vote against the motion that the purpose, and clearly this is a session to discuss litigation. Not to relitigate, but to discuss litigation and to how it should be handled. And we're the client. And under all procedures, that is always done in closed session. The results of that will become apparent as the matter proceeds. But to drop it from the calendar, I was asked, the treasurer asked what the commission's view was. I said, I can't give you an answer for the commission. I can give you only my own personal preference of how it might be handled. But it is up to the commission, the 5 of us. And that's the purpose of it being there, is to come out of that meeting having had a full discussion about the pros and cons of how the treasurer should proceed. And if the answer is proceed full barrel, that's fine. But I think that there has never been a discussion by the commission how they want, what instructions they want to give to the treasurer if there's overtures to settle, if there's overtures to do alternate dispute resolution, whatever it is. The treasurer will look to us to give them an answer.
Again, Chair Rennie, with all due respect, we're not the Treasurer's Department. That's not our job. And if the treasurer is trying to pass the buck to have us do its job for it, I don't think we should accept that buck passing. And I call the question on my original motion.
All right. Call the question. In favor?
Aye.
Opposed?
No.
Aye. All right. The motion fails. Now, the question is, do I have a motion to go in closed session? Seconded?
Second.
Public comment?
David Pilpel again, speaking as an individual. I think you should make clear what the vote was, because I only heard 3 or 4 members voting.
It was 4-1.
I believe it was
Okay.
4-1.
1 to
Right,
4.
just so that you could be clear about that. I oppose the motion to go into closed session for some of the reasons that Commissioner Keene laid out earlier. I think you can have a public discussion about whether and how to proceed. I think, as was stated earlier, there's nothing in writing from the treasurer. I don't see any representative from the treasurer's office. It's not at all clear what their process is once something is referred to them. So has the matter been referred back to the commission and the commission would initiate litigation? If so, then maybe you're proper to discuss it, but that's not clear. And if you're not initiating litigation but only urging the treasurer tax collector to do so, then I'm not sure that you're the client, and I'm not sure that you should be in closed session if you're not actually the plaintiff in the action. So there are a lot of questions about where we are procedurally, and I would resolve them by not dealing with this further tonight, but putting something in writing, having staff prepare a cover memo so that we know where we are procedurally. And at the end of the day here, I think that Supervisor Farrell will continue to contest this matter and is unlikely to pay all of the amount, in my view, is unlikely to pay probably any of the amount. And then the question is, how much in terms of public resources should we be going in? Should we additionally put in to collect what's likely an uncollectible debt? And I think that that's a strong consideration about how much money the staff, the city attorney, the treasurer, how much more money we're going to put into this effort. And where does this end? And where's the public benefit to any of this? Is this setting a good signal for the future to deter others from this sort of conduct? I'm not sure. I'm not sure at all. Thanks.
Thank you.
Larry Bush, I also oppose going into closed session. There's a bit of an irony in having Mr. Sutton make the request to review this matter, since he is himself the person who received the largest fine ever done by this Ethics Commission, which was $800,000. And we certainly never saw him come back and say to the Department of delinquent revenue, you have to go back to the Ethics Commission and ask them if they really want us to pay the money that they have decided we owe. It just got done. I think you'd have to ask the Treasurer's Office, show us where you have ever done this. With Ethics, with Health Department, with Department of Building Inspection, with Planning, with anybody. Where have you ever gone back to the Commission and said, we want to know whether you want us to collect the debt that you have levied? I just don't think it happens.
I'm still unclear that the commission chair did contact the treasurer and ask, and was this the treasurer himself, did ask what the next step is, and that the treasurer said the commission needs to give me advice on how to proceed with the collection of, with this client whose agent is refusing to proceed further with us and is demanding that we rescind these orders and close the matter. And if that's the case, it seems like the next step is litigation, and that you'll take it up in an executive session and have to discuss this. But I would urge you to stick by your guns. I would also urge you to consider the reality that this was a very egregious offense, the way this happened. This cost or changed the outcome possibly of an election. And I think you have to understand that this is not a minor matter that now can be dropped. However, I'm a little concerned with the treasurer's non-appearance in all of this. He obviously doesn't want anything in writing, so I don't think he's going to be a particularly robust litigator. It may be that this body would have to initiate the suit itself through the city attorney. In that case, you'll probably want to call Mr. Herrera and invite him in to your executive session. So my thought is you might not want to hold that session tonight. I think you might want to scrub it a little bit more and think about it. Thanks much.
Just so there's no mystery about it, and I think is that the treasurer asked what we wanted, what the commission wanted him to do, and we said, send the letter. And it's referred to in Mr. Sutton's letter that the treasurer wrote a letter demanding collection. And that is what Mr. Sutton's letter is a response to. And the treasurer has asked now for any further guidance as to what the commission wants to do. I can't give him that guidance without talking with all 5 members as to what the guidance is.
The letter from Mr. Sutton, though, is going back to the treasurer requesting dismissal of the September 30th demand letter, essentially.
Absolutely.
And that the matter be formally closed, that his client has never been convicted of anything. The FPPC has cleared him. This last paragraph is pretty insulting, frankly, given what we know.
Ray Hartz, Director, San Francisco Government. The question is, do you stand by your decision? If you stand by your decision, all it needs is in front of the public, somebody make a motion, say, let us direct the treasurer to proceed as he would normally proceed in any other such debt or any other such matter. Because if you do not, I can see it coming back again and again, every step of the process, whether it's arbitration or whether it's negotiation or whatever. You get another back from the treasurer. Now, well, they came and said this. What do you want us to do? They came and said this. What do you want to do? They did this. What do you want to do? The bottom line is he broke the law. You agreed to it. You found it. You fined him. And you send it to the treasurer, which is, I think, the normal procedure. Now, I have to agree with one of the other speakers, is I've never at any commission meeting heard any of the treasurer come back and say anything about any debts that were collectible. If it's a debt and you say it's a debt and you send it to them, they accept it and they go collect it. But why are they coming back here and saying to you, give you instructions? And very frankly, what again are you going to go back and discuss? You don't really know what it is the treasurer wants. And if you go back and you come up with some jury-rigged thing, what is to prevent the treasurer from coming back and say, oh, this isn't what I need? But again, the most important thing is we need something that the public can see, that the treasurer put you in this position, not that this treasurer had a private conversation with one individual, and as a result of that, we're now going through all these machinations. Because that's what it looks like to me. Somebody had a private one-on-one conversation, and now all of a sudden this is on the agenda. There's nothing to support it, nothing from the treasurer, nothing whatever. And again, I'm not saying anybody's telling a lie or anything else, but that's just not the way you do business. It's not professional. You don't have a private discussion one-on-one with nobody, not even other members of the commission, know exactly what was said, because it's very frankly possible that the chair maybe misunderstood what the treasurer was saying. I don't know. Do you? Very frankly, all it takes is one of you to have the integrity to say, I move, we instruct the treasurer to proceed as he would normally do in such a matter, get a second, pass it, and it will be done.
And I call the question.
Mr. Chair.
Commissioner Keene.
Yeah. I think that, rather than argue with my colleagues that they shouldn't do this, which is crazy, if you do it, we should at least take a time out. Let's take a time out. The public has told us they didn't know what this is about. I didn't know what it was about until you just told me a few minutes ago, Mr. Chair. We should I move to recalendar this to the next meeting so that we can have a little bit of a timeout, have it framed in some way that we know what it is that we're doing and why we're doing it, and we're also agendizing it in terms of that, so the public knows.
I've called the question. All in favor of going into closed session? Aye.
Aye.
No. Opposed?
Aye.
Aye.
So you not go into closed session? All right. You want to?
I thought they voted aye to go into closed session.
Pardon me?
I believe Commissioner Hannah Andrews voted aye to go into closed session.
Yeah.
Oh, you're saying aye?
Yeah.
Oh, no, I'm sorry. I voted. I vote in light of what Commissioner Keene said. I don't want to go into. I want to recalendar.
Okay.
Sure, yeah.
So it's 3-2 to go into closed session.
Is that what Beverly's? You voting to go into?
Yes.
Okay.
All right. Who's on first?
Sorry. It's late.
Pardon me?
It's late. It's very late.
All right. You want to take a break before we go into closed session?
Yes.
All right. We'll stand in recess for 10 minutes and return in closed session. As a result of the closed session, the commission has delegated me to continue to work with the treasurer to enforce his action. All right. Turning to item number 8.
Excuse me, Chair. Yeah, we just very brief. Small bit of housekeeping. We just need to do the motion about whether or not to disclose our closed session discussions.
All right.
We already took public comment on the item.
Separate agenda item.
Well, I have a motion to to disclose or not disclose beyond what I said, what took place in the closed session?
I move to not disclose.
Second.
Beverly seconded.
All in favor?
Aye.
Aye.
Comment.
On the motion not to disclose,
Excuse me, opposed?
Yes.
Yeah, sorry.
No,
Well, we need to do public comment first.
4 to 1. Go ahead.
public comment on the motion not to disclose. Given the open session discussion earlier, it would be helpful for those of us who stayed and are interested in this to get a little more explanation. You don't have to obviously disclose everything discussed in closed session, but it's not at all clear from your statement just now that you were delegated, I think what I heard is you were delegated the authority by the commission to continue to work with the treasurer to collect the debt. Is that what I understood?
Yes.
Okay. It's not at all clear what that means if this is never going to come back to the commission or if this is just one shot. And a little more explanation would be in the public interest, in my opinion. So I oppose the motion. Thanks.
Go ahead.
Ray Hartz, Director, San Francisco Open Government. I agree. Basically, we went into it with an agenda item that nobody, even one of your commissioners, said publicly that he didn't know what it was about. You went in the back, had a private meeting. Now you're coming out with something that is just as vague and ephemeral as what you went in with. And I have to agree with Mr. Pilpel. So what are we supposed to do? Just kind of watch the agenda to see if it ever comes back again? And what specifically have they empowered you to do in regards to the treasurer? Are you empowered to negotiate with the treasurer, or simply to tell him to do what he's supposed to do? And given the fact that you went into this meeting not knowing what the treasurer really expected, what is it you're going to be doing with the treasurer? You know, what we're seeing is this public negotiation between two city departments, and it's all going to be done in private, out of sight of the public. And I agree with Mr. Pilpel. I wouldn't be at all surprised if it never came back here again. And all we finally heard was that Mr. Farrell didn't have to pay the money. I was very encouraged so far this meeting that everything seemed to be going in much more positive direction. And now we get to this thing, and all of a sudden we're left with absolutely nothing. The public knows nothing about what happened with this agenda item, except you went in a private meeting. It wasn't properly agendized, and I am going to unfortunately file a complaint with the task force because this told us nothing. The law clearly says agenda items must be specifically written so that a person of average intelligence can understand what is being discussed and whether or not their interests are involved to the point where they would want to either attend the meeting or get further information. And obviously, if you look at that agenda item, since even one of your commissioners didn't understand it, and I'll be surprised, I think it's just the fact that the rest of you didn't want to admit you didn't understand it. Very frankly, I think you're doing a disservice to the public. And very frankly, again, going into private session tonight, a closed session tonight, and then coming out here like this was some sort of a house is on fire, we have to deal with this right away. I don't understand. What I should have seen was somebody have the integrity to say, we made a decision, let's stand by our decision, let us simply direct the treasurer to collect the debt, and if he has a concern, let it tell us in writing what that concern is. Right now, we know, the public knows nothing about this. Absolutely nothing. Any of you want to disagree with me on that? And you've got carte blanche to do whatever you want. And this all came about as a private conversation with you and the treasurer coming in here, and as somebody else said, is hearsay. I'm not saying you're not being honest or anything, but the fact is it's all...
Thank you. I think we voted on not disclosing other than what disclosure has been made thus far. But seeing I didn't have public comment before the vote, following public comment, I'll call the question again. All those in favor of not disclosing?
Aye.
Opposed?
No.
All right. It's carried 4 to 1. The next item is discussion and possible action on items for future meetings.
Mr. Chair, I had a number of things that I was going to bring to the attention of the committee for future meetings, but in light of the hour, I'm going to defer it to the next time.
Any public comment?
Phil Pell again, speaking as an individual. In the next agenda item, you've got the Executive Director's report with this nice, colorful chart of upcoming things. The last director and acting director also had a list of other initiatives and things that were upcoming before the commission. So I would ask that in future revisions to the colorful chart that we have a section of upcoming things before the commission. I think it's incredibly helpful, not just to have this, which is, by the way, very helpful, but to see that list of things coming up in the next few months. I think that was very helpful to track. Hopefully helpful for you, but certainly helpful and hopefully helpful for the staff, but also very helpful for the public to see what's upcoming in the next few months. So I would hope that we could work that back in. Thanks.
All right, turning to item 9, which is a discussion of the Executive Director's report. And I again want to compliment you on what I thought was a very well prepared report. My only comment was on paragraph number 4, Investigation and Enforcement Program. I would think we need to have a little more information on where those matters are, and because I know some of them have been referred out. But other than that, any other commissioners have any comments, or you want to elaborate?
No, given the lateness of the hour, I will let the report stand as is, but I did just want to highlight one item under number 2, and that is that the audits are being finalized by the audit staff, and they expect to be done in February, and I know that's been a question longstanding. And I do appreciate the comments and feedback about item number 4, providing us more clarity as we can, and certainly to Mr. Pilpel and others. Yes, the attachment for this month was to try to identify some of the ongoing deadlines we're working with, but it certainly is not meant to replace that larger list of projects that the Commission wants to go forward on in terms of issues. And so I took a pass on that this month, but I do look forward to bringing that back for the Commission's discussion and the public as well.
Any public comment?
David Pilpel again, speaking as an individual. And again, thank you for this colorful chart. I hope this will be a regular feature as an attachment to the Executive Director's report. On the question of the item 4, the investigation and enforcement matters, my understanding is that there were a number of complaints pending that weren't acted on by the acting director, and we're waiting for Leanne to arrive. So I hope that there will be some movement in the next month on some of these items pending. And I thought that in coming months we were going to have a broader public discussion on the enforcement program, ways to make some of this information more public, ways to notify complainants earlier that their complaint is received and the status, et cetera. So I'm looking forward to that in the fullness of time. And although apparently the new director likes a different font than the last one, and I noticed that throughout, there is a chart missing here about the items referred to BDR. As we talked earlier about BDR, there was a chart that used to be in this report. I recall, for example, Chris Jackson, who was fined by the Commission many years ago now, and I thought was on an installment plan. I don't even remember anymore, moved to Oakland. I can't tell from this what the status of his payment plan is, and I thought that there were others that were at BDR. And there's no other public accounting for those outstanding fines and fees overdue. So I would hope that or some version would be back in the ED's report in future months. Thanks.
Commissioners, Ray Hartz, Director, San Francisco and Government. The only comment I have on this is on page 3, item number 4, Investigations and Enforcement Program. The very last item, the Sunshine Ordinance 0. For years now, there has been absolutely nothing, or if there was anything, it was the number 1 there. Let me remind you, although I know you all know this, that the bottom line is the Sunshine Ordinance Task Force passes makes the determination as to whether or not the ordinance has been violated, issues order of determination, and then send them over here. There has never been an enforcement of an order of determination by this body, even though that is your remit. Basically, the task force has no authority to enforce them, and you do. I can understand it also in the respect when we saw what happened with Jewel Gomez, when you unanimously recommended to the mayor she be removed and he ignored you, and then we got you to send another letter a year later and unanimously reminded him that you had made that recommendation and he ignored you then. And I guess I might be a little gun-shy, too, if I thought, gee, if I'm going to send stuff over and he's just going to ignore us, that's kind of embarrassing. Bottom line is the Sunshine Ordinance needs to be enforced. You have gone through literally days and days and days of meetings with the task force, setting up rules and regulations and all the other. And then when I had my last hearing, even though it typically took 6 months for a referral from the task force to this body to be heard, mine was referred and scheduled in 6 days. And it was announced the day after I left the state and heard the day before I got back. If that doesn't sound like somebody got together and planned it out, I don't know what else is. And very frankly, I think Mr. St. Croix is probably one of the worst things that has ever happened to city government in this city. And I'll be honest with you, of all the people that I deal with in the city, I've never wished ill of anybody, but he was the only one I've ever been so glad that he was gone, because I think his whole idea of the executive director's position was to prevent any city agency or any city elected official being held responsible for anything.
Thank you. Item 10, discussion and possible action on the draft minutes for the Commission's meeting on November 23rd and January 5. I will take them separately. Do any Commissioner have any corrections or additions to the minutes for the November 23rd meeting? Any public comment? Do I hear a motion to approve the minutes? Move to approve. All in favor? Aye. Hearing no opposed. It's carried unanimously. Turning now to the minutes for the meeting of January 5th, 2016. Do any commissioners have any revisions or changes or amendments to those minutes? Public comment?
David Pilpel, speaking as an individual. I just noted a number of typos and misspellings as to people's names on page 2, 1, 2, 3, 4, fifth paragraph. It should be Mr. Ababan. I believe the individual that's referred to as John St. Clair is actually John Sinclair. I believe Hulda Garfolo. Is it Hulda? Right, and it's misspelled as Helda. Charlie Marsteller is listed as Charlie here. He was listed as Charles in the other set. I believe Sarah Matlin, who was here tonight, was referred to in written testimony as Matlin. I believe it was Rachel Richman, Richman, not Ridgman. I believe Debbie Lerman spells it Debbi. So those are the things that immediately caught my attention, but I would just suggest that the content is probably okay, but if someone can just do a pass and be sure that people's names are spelled right. Thank you.
Thank you. Those corrections as to spelling, do I hear a motion to accept the minutes?
Move to accept.
Second?
Second.
All in favor?
Aye.
Opposition? Hearing none, the minutes are approved unanimously. And turning finally to item 11, do I hear a motion to adjourn?
So moved.
Second?
Second.
All in favor?
Aye.
Meeting is adjourned.